The Honorable, the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning. We are glad to be back in oral argument live in our historic courtroom here in Harrisburg. Welcome all of you. Try to set this up carefully to be extra protective while still doing oral arguments. My first opportunity to be on the bench as chief. Tomorrow we'll be doing a special program for Justice Taylor, and just to acknowledge him as a great chief. For many, many years, voluntarily stepped down to give me an opportunity to for 2 years for no other reason. I said thank you many times. I continue to say thank you till I go on my last breath. So with that, we'll call the first case.
League of Women Voters of Pennsylvania versus Veronica Degraffenreid, appeal of Shamika Moore. Representing appellants is Mr. David Patinsky. Representing the League of Women Voters is Miss Mary Catherine Roper.
I apologize, it's so dark in here. We have nothing to do with that. I think it's the Capitol building. We'll have to make some inquiries into why that is. And there's a rational basis for that. I noticed that in the hall when we walked in.
Maybe our eyesight.
Didn't do it in the last year. Could be. I'm going to introduce the case, and before you argue, tell me if I got close or correct me if that's necessary. And as you know, we're at a high court, and it's not necessary to get into facts at all, go into your argument, and there's no time limits. Tell us what you need to tell us. This case pertains to the Victims' Rights Amendment, a proposed amendment to Article 1 of the Pennsylvania Constitution to provide 15 protections for victims and others directly impacted by crime. Supporters of the amendment appeal from the Commonwealth Court's order holding that it violates Article 11, Section 1's separate vote requirement because the proposed amendment addressed multiple subjects but was presented to the electorate in a single ballot question. Mr. Patinsky, arguing on behalf of the appellants, please proceed.
Thank you, Chief Justice Baer. May it please the court, David Patinsky from Aplts, representing intervener appellants. It is our position that the disposition of this appeal is completely controlled by this court's 2005 decision in Vermont. That case completely disposes of this appeal in our favor. Now, in Vermont, they established a two-part test. The first part was to determine whether the multiple amendments were sufficiently interrelated to be presented in a single ballot. And in Vermont, there were two variables that were put in one ballot question. And the court, in deciding that issue, adopted Justice Szwerc's concurrence in Pennsylvania Prison Society, where Justice Szwerc said that in deciding whether multiple amendments could be put in a single ballot question, you looked to see whether they were sufficiently interrelated. And in Vermont, they found that the two bail amendments were sufficiently interrelated because they both dealt with the disallowance of bail. One amendment added for disallowance of bail to capital offenses where there was a possible sentence of life imprisonment, and the other amendment provided anew that for preventive reasons, for the victim and the safety of the community, you could have disallowance. And the court found both amendments were sufficiently interrelated and could be put in a single ballot question. Here,
Counsel, I may share with us how you justify the single vote when the majority of the amendments require victim participation, yet within the same bill, you're shielding the victims from having to answer questions or interrogatories or participate in that decision. Share with me how that's interrelated and polar opposite.
well, first of all, Your Honor, I know that Judge McCullough, in her opinion, she's really fine, but I think she got this wrong. The fact is that the amendment, it says that a victim can refuse an interview, deposition, or other discovery request. It deals only with discovery. And it's giving the victims a right to refuse discovery. Well, the fact is, there is no right in the Constitution. There's no right in Article 1, Section 9 of the Constitution, which is what Judge McCullough relied on. There's nothing there that provides an accused with discovery rights from a victim. Article 1, Section 9 deals only with two subjects. One is the right of confrontation and the right to subpoena witnesses for trial, and the other has to do with obtaining exculpatory evidence from the prosecutor. So there's nothing in Article 1, Section 9 giving an accused the right to discovery. And in fact, there's nothing in the Pennsylvania Rules of Criminal Procedure which gives an accused the right to discovery. So that right is to protect victims, just like all the other rights in the amendment are to protect victims. Now, yes?
If I might follow up on Justice Stocken's question, because I don't think you answered his question. His question was, how do you explain the interrelationship or the intertwining of all of these rights when you have two such disparate rights that are being afforded victims within this constitutional amendment?
I apologize if I didn't answer that. The answer is they're not disparate rights. They're all related to protecting victims' rights in the criminal and juvenile justice systems. Every single one of these is designed to protect those rights. So they are related. It's no different than the two bail amendments that you had in remote. These are all interrelated to protect victims' rights. And if you look at remote, you'll see the court there found also persuasive other formulations of the subject matter text. They said they were persuasive. And those were where there's a common goal, where they're germane to the accomplishment of a single objective. And these are all in pursuit of a common goal. Give victims these 15 rights, and that's why they're sufficiently interrelated. So,
Although the underlying purpose of the single subject rule when it comes to legislation, the single vote rule when it comes to the Constitution, is to prevent log rolling, so that the components cannot put multiple things together, some of which the voter wants, some of which the voter doesn't want, and compel the voter to vote for that which she or he dislikes in order to get what they like. And again, that's the origin of these rules in all over the United States, but in Pennsylvania. And doesn't this create that problem? I have some empathy for your clients, and I might want to vote for the notice provisions. But I certainly don't want to vote that before somebody is released at the conclusion of their jail term, they have to be held until something can be put together for the victim to come and have a say, which might be 20 years after sentence was imposed.
Well, Your Honor, that very issue was in Grimaux, because in Grimaux, you had two different bail amendments, and they were in a single ballot question. And in Grimaux,
I think, respectfully, you overstate Grimaux. They had two questions, not 15.
that's correct.
And we have to draw lines, and this is true in every one of these cases. Most of us face multiple of them. And the court held that they were both very much related to a single subject. Here, it's much easier to hypothesize multiple different ramifications and subjects. In fact, and you can comment on this, a couple of the amici and the Attorney General all said that the amendment process was not designed for this type of modification of the Constitution, and what should have occurred is your client should have sought a constitutional convention.
Well, Your Honor, the Attorney General didn't say that, the governor said that. The Attorney General is supporting us. There's nothing, let me just address that and then I'll come back to the first one. There's nothing in Article 11, Section 1, which says that if you have a so-called sweeping or complex amendment, it has to start with the Constitutional Convention. You cannot find that anywhere in Article 11, Section 1. And that's therefore not something that can be imposed or required in Article 11, Section 1. There are a plethora of rulings by this court that says when you have a statute that omits something,
Counsel,
you can't.
considering that there were 15 separate rights, what was the reluctance or hesitancy to submit each right individually so that the voters can select that, as opposed to having judicial involvement as opposed to voter approval?
Well, Your Honor, I think that's a discretion that the legislature chooses to exercise. Here they exercise the discretion by putting them all in. I would note, not answer to Chief Justice Behr's first point, that in Grimaux, Justice Cappy wrote a dissent. And one of the points he made in his dissent was that the subject matter test of Justice Saylor put the voters to the very Hobson's choice that Your Honor referenced, namely, vote for all of the amendments or none of them. But that was the losing argument in Grimaux. That was what Justice Cappy said in his dissent. Because the subject matter test is designed to have multiple amendments that are sufficiently interrelated in one single ballot. And that's what happened here. And in fact, in the ballot question itself, they actually, with the 75-word limit that's imposed by statute, they actually were able to put 8 of the amendments in that ballot question. So when the voters voted, they knew 8 of the 15 amendments, and they could make a decision about whether they wanted to support them or not. And in addition, you have the Attorney General's plain English statement, which accompanies an amendment, which is posted in all voting polling places, which contains all of the amendments, so the voters know what they're voting on. But the fact is that the genius of Justice Saylor's test, subject matter test, is to permit sufficiently interrelated amendments to be put in a single ballot. And that's what was done here, because they were all viewed as achieving a common purpose. The common purpose being protecting victims and giving them rights on a level that were equivalent to what the accused has in the Constitution. So that was the purpose, and it was a common purpose, which the court also found some persuasive alternative view of this. And so that's something that the legislature had to do, and therefore we say that they were all sufficiently interrelated and they're capable of being put in a single ballot.
Counsel, I just wanted you to clarify for me in follow-up to one of Justice Stockery's earlier question. Under the amendment, if this language is approved, what happens in a post-conviction proceeding if the victim or the victim's family is not available to provide input as to whether an individual defendant should be released?
Well, Your Honor, we would say that, first of all, they should be invited to participate. That's the purpose of the amendment. They should be invited to participate. If they decline, they decline. But they should be invited, and they should be able to be heard. And I mean, they are the victim.
What if there's no one to invite? What if they're totally unavailable?
Well, if they're unavailable, then there's no reason why the proceeding doesn't go forward. But they should be invited to participate if you could find them. That's the whole purpose, is to give victims rights that are equivalent to the rights of the accused. And that's why all of these amendments were put in a single ballot question, because they all were designed to achieve that common goal.
Counsel, right number 13, at least by my count, it's number 13. Proceedings free from unreasonable delay and a prompt and final conclusion of the case and any related post-conviction proceedings. Doesn't that patently relate to and impact the judiciary's right, this court's rights, under Article 5, to set proceedings in the courts of Pennsylvania?
Well, first of all, Your Honor, there's nothing, I emphasize this, there is nothing in the Victims' Rights Amendment which changes any of the language in the article protecting discourse rights.
This does. In my reading of this is guaranteeing a victim a right that heretofore this court would be in the exclusive position to afford to anyone. And this is saying, courts, you can't really control these proceedings now in the manner that you see fit, because victims have a right to proceedings free from unreasonable delay and a prompt and final conclusion.
Well, Your Honor, I believe that would come up, and this court would have to decide how to reconcile that Victims' Rights Amendment with the proceedings which this court has a right to rule on. But it doesn't change any of the language of the article giving this court power. And I think that's important, because if you go to, again, Grimaud, this is the second part of the Grimaud test, the Applts in Grimaud, like the Aplts here, argued that the bail amendments affected other provisions of the Pennsylvania Constitution.
Counsel, proposed amendment 12 is the quick return of property of a victim when the evidence is no longer needed. Share with me how currently the return of property of the defendant is a civil proceeding. So are we now going to differentiate the type of proceeding that for an individual who wants his return of property or her return of property after being accused and saying, I'm not guilty, but yet we're going to indoctrinate constitutionally the return of property for a victim in a different procedural forum? How does that work?
Well, Your Honor, I'd like to point out that with respect to that amendment, there is already provision in the Victims' Rights Statute, which exists, a provision giving victims the right to the return of their property. So that's
a whole other issue.
Yes.
What is the necessity of this constitutional amendment when we have the Victims' Rights Statute for which courts adhere to?
First of all, it doesn't cover all of them, but second of all, there's a difference between having a right in a statute which can be changed by the legislature and having a right in the Constitution. And again, I know I'm repeating myself, but the whole purpose of this amendment was to put this in the Constitution so that victims had constitutional rights equivalent to those of the accused. But the fact is that right already exists and has been procedurally worked without any problem.
I'm sitting here trying to work this through, as we all do on every case. And the linchpin to your argument, respectfully, is victims' rights is equivalent to German or equivalent to anything where it's a sufficiently unifying subject to justify all of this. But it seems to me that the term could encompass infinite rights. You only chose 15 and not 100 or 200 or 300. But it seems to me that it's so amorphous as to arguably be meaningless. In that you could say that it's a victim's right to have a ride to and from proceeding. And you could say it's a victim's right to have a meals during the proceedings so that they didn't have to leave the courthouse. And you could say that they have to be gluten-free. And you could say that they have to be vegetarians. And then you can say it's the victim's right not just for restitution, but be compensated in X dollars per day for the days that they have to be in the courthouse for a proceeding. And on and on and on and on. So those are just typos, but the question is, isn't victims' rights so broad, so amorphous, as to almost not be able to define anything? As distinct, let's just say, from German, which is a couple bail provisions.
Well, you're right. First of all, hypothetical behavior, not in this amendment.
Well, I understand.
Right? And what's
I'm just
interesting,
saying you could put anything in there, therefore the question, again, and I'll be quiet and listen to the answer, is victims' rights really a single subject at all?
well, I think the answer is the answer Justice Szwerc did in establishing this test in his concurrent opinion, which became the holding of the court in Vermont, which is, are they sufficiently interrelated? I think to address your hypothetical, can they be vegetarians? Can they be given rights to the proceedings? I think the court could find those are not sufficiently interrelated. That's the genius of the test. But the fact is, all of these are sufficiently interrelated because they're designed to give victims rights in the Constitution, which are equivalent to rights for the accused. And so that's why this was done. And they are sufficiently interrelated. And I point out that in Grimaud, not just that Justice Catton used the very Hobson's choice argument that Aplts make here, that you shouldn't be put in a position we have to prove all or none, as was done in Grimaud, to the evidence. That is antithetical to the subject matter. And he also said these were the losing arguments that you need literal compliance with the separate vote requirement in Article 11, Section 1. And of course, again, the Grimaud test, the subject matter test, is the very antithesis of literal compliance. And I would add one other thing about literal compliance, which again was in the losing argument of Grimaud, Justice Catton's dissent, that the literal compliance statement that everybody relies on, including Aplts here, comes from two Supreme Court cases, the Kramer case and the Tawson case. And we point out in our briefs that those two cases have nothing to do with the separate vote requirement. The literal compliance that was advocated in Kramer and Tawson was to the advertising provisions in Article 11, Section 1. And those courts said you have to have literal compliance with the advertising provisions. Nothing to do with the separate vote requirement. So these are arguments which were lost in Grimaud. And I point out another argument that was lost in Grimaud, which is the argument in Grimaud that the bail amendments conflicted with Article 1, Section 1. The very article that Judge McCullough found here conflicted with victim rights. And what did the court say in Grimaud about that? Well, first they said you can only invalidate, you can only nullify an amendment in a question if there is a facial or patent effect on a constitutional provision. And to emphasize, they underlined the word facially, to emphasize and underscore the fact that they meant that. And when they looked at the argument that appellants made in Grimaud about the impact of the bail amendments in Article 1, Section 9, they said, and this applies here as well, they said there's been no change in the language in Article 1, Section 9. Article 1, Section 9 is Same after the amendment as it was before the amendment, because that's how you apply a facial change to another constitutional provision. So,
could I ask you about Article 5? I haven't heard too much discussion of Article 5. In Bergdahl, we held that the language offended our exclusive rulemaking power. Could you tell us how you would address the problems that have been cited regarding the open-ended power granted to the General Assembly to further provide and define for these victims' rights, such that if the amendment becomes law, presumably the General Assembly is empowered to make rules in this area, which would seem to present a Bergdahl problem as going to our exclusive rulemaking power under Article 5. And specifically, as you know, we have robust rules of criminal procedure. Could you explain to us how this does not tread well over into that area of our law?
well, you're right. I don't think that there's anything in the Victim Rights Amendment which changes, alters, in any respect, what's in Article 5. And so the question, if there's a question that comes up as to how do you reconcile something that's in the Victims' Rights Amendment with Article 5, which again is going to be a decision made by this court. The answer is that this court will resolve it. And that doesn't mean that the amendment should be nullified. That amendments which were approved by 74% of the voters should be nullified because there's going to be a future case or controversy in which this court will decide whether or not and how to reconcile something that's in the Victims' Rights Amendment and a constitutional provision. I mean, that's what this court. That's what this court did in the Edmonds case, as we pointed out. When you have a conflict between a constitutional provision and another provision, and in Edmonds you have that, you establish, as you did in Edmonds, a four-factor test to decide how you're going to rule on it. So all we say is that you shouldn't nullify these amendments because of a future case or controversy where this court itself or a lower court like the Superior Court will have to rule on some conflict.
Just a brief follow-up, because you touched on something that I meant to ask you. It's a direct question. For constitutional purposes, do you maintain there's any difference in the decision we have to make based upon whether this number was 74%, 34%, or 99%, or 1%? You don't maintain there's any difference in the decision we have to make, do you?
No, I don't.
Okay, all right, thanks.
As long as it's 50.1%, that's all that matters.
I think we understand the argument. I think all our questions have been answered. If you want to take a sentence or two, though.
Yeah, I'd like to just address, I think, the point about the governor's brief. There was another issue raised by Judge Szwerc, in her opinion, which I just want to address briefly.
Very brief.
Thank you.
We understand.
Thank you. She took the position that Rouleau should not be applied because there's a difference between where you have an amendment to existing constitutional provisions and an amendment which creates new constitutional provisions. And again, I'll just point out two things about that very briefly. One, there's nothing in Article 11, Section 1 that suggests you should be making that distinction. Nothing whatsoever. And two, to support her position, she cited to Justice Todd's decision in the Szwerc case, where Justice Todd referred to that fact. But Justice Todd referred to that fact in the Szwerc case, but it did not involve subject matter jurisdiction. It involved subject matter test. All it involved in Szwerc, when Justice Todd addressed the subject, was whether the amendment which increased the age for retirement for Supreme Court justices from 70 to 75, whether it was misleading in the way it was disclosed in the ballot questionnaire. It had nothing to do with the subject matter test. So that's what I have. I thank you very much for your time.
Thank you. Ms. Roper?
Mr. Patinsky is much taller than I am. Good morning. May it please the court, Mary Catherine Roper from the ACLU of Pennsylvania, representing the Applts, the League of Women Voters of Pennsylvania, and Lorraine Hall. Your Honors, this isn't news to anyone, but our Constitution not only details how we govern ourselves, it is also a statement of our values. And one of the principles set forth in that Constitution that this court has fiercely guarded through the years is the principle that it is for the people only to amend the Constitution, not for the legislature, not respectfully for this court. And that is the promise that is contained in the language of Article 11, Section 1, which is that when you have more than one amendment, those amendments need to be set to the people in separate questions. I will concede that the most literal interpretation of that provision is the one set forth by Justice Cappy in his dissent in Vermont. It is, however, the fact that we have a little more flexibility than the actual literal meaning of those words in the interrelatedness test that this court has adopted does not mean that those words are simply out the window. There is a middle ground. The middle ground is not to talk about some vague, broad subject matter, but in fact to look at the way that this court has applied the question of whether the proposed changes are sufficiently interrelated to be considered one objective, one change. This proposed amendment manifestly does not meet that test. In addition to the notice and opportunity to appear and opportunity to participate in various court proceedings and non-court proceedings, when we're talking about parole, etc., the proposed amendment offers property rights, right to return of property, right to restitution. It offers some rights that I think are not well defined and have no analog, honestly, in our law, such as the right to a reasonable protection from the accused. These rights take effect in all manner of different proceedings and honestly in different venues when, again, we're talking about right to parole as well as those that occur during the court proceeding. In addition, of course, the proposed amendment not only sets forth court procedures itself when it's talking about how a dereliction of the victim's rights are raised by either the victim or the attorney for the government, but also explicitly provides the General Assembly with the right with the power to expound on and define how these rights are implemented in court proceedings, as we have argued and as this court has noted, that infringes on this court's otherwise exclusive authority over court proceedings. In their papers, the appellants point out that there are some exceptions in the Constitution to this court's exclusive authority over the management of court proceedings, and they are correct. Each one of those has had to be set forth specifically in the Constitution, because otherwise the court's authority under Article 5 is exclusive and all-encapsulated. The proposed amendment, I will not dwell, I'm going to go actually to the second part of the test and talk about the effect on other parts of the Constitution. And I am doing that in part to address a couple of arguments made by counsel for the appellants that I think cannot be left unresponded to.
Counsel?
Yes.
I don't want to interrupt your argument when you move on to that point, but from the perspective of interrelatedness or looking for a single topic that is encompassed, what's wrong with the topic being rights of victims of crime?
In fact, Your Honor, this court has never approved an amendment that is under such a general rubric.
So what's wrong with that? I mean, I'm asking.
But the answer is that it makes a mockery of Article 11. So let me just provide an example. I won't even use all of the rights in the proposed amendment, but let's say that if this was a proposed amendment solely about the rights of victims to notice and opportunity. But as part of that, also granting power to the legislature to define those rights, also creating a mechanism for the enforcement of those rights. At this point, if we look at the examples of the interrelatedness test, both from Justice Szwerc's writings and from the majority in Vermont, we look at the governor would call it a functional test, perhaps, but I'm going to call it a little bit of a mechanistic test. If what you are doing is changing, is creating categories when bail can be denied for the purposes of public safety, you are broadly serving the interests of public safety. That's like saying you're serving the interests of victims' rights. But you are doing it through one specific change and not through a whole variety of changes. There's nothing in the law that suggests that if the proposed amendment had gone on to set forth multiple conditions and procedures with respect to the granting of bail, that would have been considered one thing. That is just far beyond the language of the law.
Ms. Rucker?
Yes.
Do you see any problem with the fact that the title of this, the gist of the whole amendment with its 15 parts is victims' rights, but some of the rights really are accorded to claimants who have not been adjudicated to actually be victims?
Your Honor, I think that informs, honestly, both aspects of the Grimaud test, because in addition to providing rights, no doubt, to complaining witnesses, it also provides rights and access that never existed before to people who are legally peripheral to the prosecution. When we're talking about family, friends, we don't even have to go that far. I think my favorite illustration of this is there's a fight in a bar and some chairs are broken and the bar owner is a victim because he suffered harm from the alleged crime. He too is entitled to refuse to produce information in response to a subpoena like the security footage. He too is entitled to notice and an opportunity to participate in all proceedings, etc. So the interjection of this very broad category of people, many of whom have no existing role in criminal proceedings, is itself a significant change in the way that our criminal courts proceed, in the way that we balance the power of the government and the power of the defendant. Now we have a whole Article 9, Article 1, Section 9 is about the balance of power between the government and the defendant.
Right.
But now we have a third party in there.
Isn't it possible that in some cases, victims' rights under this amendment would be accorded to someone who, after the adjudication, it turns out wasn't a victim at all?
Well, certainly one of the arguments made by the amici is that no one is necessarily a victim of a crime until a crime is established, and that doesn't happen until the end of the proceedings. Yes, and that is a fundamental aspect of this, as Counsel for Appellants reiterated, that the whole purpose of the amendment is to elevate those people who are affected by crimes or who allege to be affected by crimes. Every once in a while there's someone who wasn't actually genuinely that. To elevate their rights to those who are compelled to be part of the criminal proceeding.
Okay, thanks.
Doesn't your argument in that vein kind of skip the Grimaud test and invite this court to issue a decision based upon the merits of each individual amendment, which, as your opposing counsel argued, is something that's preserved for in the future should the court endorse this law? Your Honor, I don't think any of our arguments skip the Grimaud test. I think we are very, very focused on whether this proposed amendment accomplishes one thing or accomplishes a whole lot of disparate things, and separately, whether it is in fact simply a self-contained thing or whether it directly changes other parts of the Constitution. You've identified quite a few parts of the Constitution. We did not, both in terms of page limits and just economy, we did not write separately about the impact on the presumption of innocence, but the amici did, and we think their arguments are well taken.
You don't contest that, as a general proposed matter, that all amendments are targeted at victims' rights?
I disagree with that, Your Honor. I think that there's a great deal in the proposed amendment that is not, while it is all packaged together, as a tautological matter, when it lists victims' rights, it's creating victims' rights. I can't disagree with that. But it also sets forth court procedure. It also sets forth a power of the General Assembly to expand on and define these victims' rights and procedure. And it also directly implicates procedures that are defined in other parts of the Constitution, whether that's the pardon procedure, whether that is the presumption of a pretrial release contained in Article 1, Section 14.
I guess I'm just a little surprised because I thought your stronger argument may have been the second part of the Grimaud test, and I guess I expected that you would concede the first test, the sufficiently related.
Oh no, Your Honor. I think that these are not at all interrelated, and to that I go back to the first articulation of the test, which was in the Justice Saylor's concurrence in Bergenhall, where he says the elimination of the face-to-face requirement in the right of confrontation creates an entirely different effect than allowing for remote testimony or empowering the legislature to create a procedure for remote testimony of child witnesses. Similarly, when you have rights of notice and an opportunity to participate, I would concede those are interrelated, but I don't see how they have any relationship to the right to return property. I don't see how they have any relationship to the right to refuse to respond to a subpoena. I don't see where they have any relationship to a right to restitution.
I don't want to argue with you, but it would be the right of the victim's restitution, the right of the victim to receive the return of the property. And you can parse it, I guess, if you may. And I follow what you're arguing. I just might not agree with it.
I see that. I don't expect you to agree with everything I say. I just think that is tautological. If you say we're creating a bunch of victims' rights and that is then how we pass the constitutional test by calling them all victims' rights.
Counsel, could you respond to opposing counsel's argument that the language of the amendment, which empowers the General Assembly to further provide and define these rights, in their judgment would not offend our exclusive rulemaking power under Article 5. What's your position on that and why?
Your Honor, the bulk of the proposed amendment, as I've said, not all of it, but the bulk of our proposed amendment relates to criminal prosecutions and literally what's going on in the trial courts during the course of a criminal prosecution. The General Assembly, I don't see how they expand on and define those rights and provide for those rights without describing and dictating what happens in the course of criminal prosecutions, which, as you have noted, are governed by a very detailed set of criminal procedure rules promulgated by this court. I will mention that we also point out that in addition to that derogation of this court's authority over judicial procedure, the enforcement provision of the proposed amendment itself creates a judicial procedure quite apart from any action that would be taken by the judiciary and is itself, I think, an exception to the exclusive right of the judiciary to govern those issues.
And you had tried multiple times to turn to the second half of the Devon test, which is the impact on other tests. I actually think you've commented on that fairly extensively. Before you conclude, there's anything else you want to say on that?
Certainly, the one thing that two things I want to make sure I touch on there is, first of all, the argument that under Grimaud, the 15 words talking about the presumption of innocence and the conclusion of Justice Aiken, that because there was no change to the language in Article 1, Section 9 about the presumption of innocence, that there was no patent substantive facial effect on that. That's 15 words out of a much longer discussion in which he talks about the other arguments made about how that proposed amendment purportedly affected other parts of the Constitution, and never in the rest of that, and in fact in the same paragraph that those 15 words appear, it begins with a sentence about not having a substantive effect. Yes, the bail amendments do not substantively affect the right to defend oneself, the right to be free from excessive bail, or the reservation that Article 1 rights remain inviolate. So there's simply not a fair reading to suggest that the affecting other parts of the Constitution test is reduced to a question of redlining. And finally, just on the right of use of compulsory process, that portion of Article 9 does not talk about Brady rights of obtaining evidence from the prosecution. What it says is that the defense shall have the right to use compulsory process in their defense, which, while that could include subpoenaing witnesses, this court has held also includes subpoenaing documents. My illustration of the bar owner who doesn't want to turn over his security footage, indeed we could go directly to the victim, and someone is accused of shoplifting from Rite Aid, and Rite Aid, for whatever reason, says, no, we're the victim, we're not turning over the security footage.
Counsel, may I ask one question? With regard to the amendment about the notice requirements, do you believe they're specific and interrelated enough to pass constitutional muster?
Some of them, yes, Your Honor. I would say I would carve out notice and participation in parole proceedings, because those are dealt with quite separately in the Constitution. And furthermore, we still have the introductory language about the legislature being able to define these rights, and the enforcement language about how these rights of notice and opportunity would be heard, that raise problems in terms of affecting other parts of the Constitution. It certainly would be possible to create a package of rights relating to notice and opportunity to be heard that would pass the Grimaud test. That's just not what we have in the
I don't usually do hypotheticals. Really? They're reserved for me. Hypothetical. There's an amendment. The legislators are sophisticated enough to create legislation regarding notice requirements that becomes constitutional. There, in many of the amendment rights, or the proposed amendments, are really requests that are made to the trial judge in the ordinary course of a criminal proceeding, that being the return of property, that be refusing to provide discovery, whether it's mandatory or discretionary, as we have in our court. So the question I have is, what would your argument be if the General Assembly passed just a notice requirement, making it mandatory and constitutional for the victims to be present? And then the General Assembly can supplement that with statutes, such that, as counsel has argued with Justice Szwerc's question, then those issues may become a future case of controversy as to whether they're impeding on our proper rights. In essence, what is your argument if this were not to survive, my colleagues and I? What would be your argument if they come back and say, hey, we're just going to do notice requirements, make that constitutional because victims have a right, because we have heard of certain district attorney offices not providing notice, such that, that's unfortunate for the victim. But now if it's constitutional, and the General Assembly can supplement that constitutional right with a statute for which they pass our smell test, then your argument would seem to be all for naught because they'd be getting what they want anyway, correct? Or do you disagree?
Your Honor, I'll just start with the basic premise that what the legislature wants is not supposed to be the test. It's supposed to be what the voters want. It's certainly, I agree with you, the legislature could craft a constitutional amendment that narrowly provided a right, a constitutional right, similar to the statutory rights that exist, for notice and an opportunity to participate in court proceedings without allocating to the legislature the power to create the procedural rules that dictate, without itself creating a motion practice, essentially, independent of this court's procedural rules. There's a way to do this, and that is our argument. Our argument is about Article 11. This just isn't it.
Ms. Roper, am I correct that if this proposed amendment does not pass constitutional muster with this court based on the violation of the single subject doctrine, that the legislature can then go through the process again and propose all 15 of these items relating to victims as independent constitutional amendments? There's nothing to preclude them from doing that.
No, and in fact, that's exactly what happened after this court's decision in Bergdahl. The legislature went back and disaggregated the not sufficiently interrelated pieces of that proposed amendment, and they both passed. That is what Article 11 commands, not that the legislature can't do these things, but that the voters get the authority to decide which things become part and who don't become part of the Constitution.
Thank you.
Thank you. If you have anything to say in conclusion, feel free to proceed. I think we understand your argument.
Thank you, Your Honor. I think our papers amply cover the others.
Well argued on both sides. Thank you.
Robert Mallory versus Norfolk Southern Railway Company. Representing Mr. Mallory is Mr. Daniel Levin. Representing Norfolk Southern is Mr. Bruce Merenstein.
In this case, a Virginia resident filed an action against the Virginia Railroad in Philadelphia, alleging that he was exposed to harmful carcinogens when he worked for the railroad in Ohio and Virginia. The trial court sustained the railroad's preliminary objection to dismiss the case for lack of general jurisdiction over the railroad in Pennsylvania. In so doing, the trial court declared Pennsylvania's statutory scheme requiring foreign corporations to submit to general jurisdiction as a condition of conducting business in Pennsylvania as violating the due process and notions of interstate federalism. The Virginia plaintiff appealed directly to this court, which is Detroit. Mr. Levin, please feel free. Let me just say to you, we apologize that the lights aren't on. We're trying to do something about that. We're not sure what's going on with the building.
Thank you. I want to thank the court for providing the opportunity to argue this case. Specifically, the facts presented by the court are correct. This case is about whether Norfolk Southern can be subjected to general jurisdiction based on the voluntary actions that it did, the voluntary consent when it registered under Pennsylvania law to be a foreign corporation. And I think what is important about this, and where I think Judge New's opinion was wrong, is Judge New took the registration statute as a mandatory and coercive act that required Norfolk to register.
How is it not? How is it not?
The registration statute, it encourages registration, but the punitive effect of not registering doesn't prevent a company from doing business in Pennsylvania. It restricts perhaps their access to the courts, the right to bring a lawsuit, which the Supreme Court of the United States in Lehigh, and Company, 366 U.S. 276, found as a permissible act of a state to regulate foreign companies, that it's constitutional to regulate their court and access to the court. What the registration does not do is require defendant and provide punitive effects for them to require them to register. And in fact, the registration statute only applies to interstate activity in the state. That's where it's requesting the registration. When Norfolk reviewed the registration statute and decided to register as a foreign corporation, as a Fortune 500 company, they made a decision, a voluntary decision, to register here, perhaps to get the benefits of being a Pennsylvania corporation, have access to the courts, to be a member of the Pennsylvania community. It was but it was nonetheless a voluntary act. And I think the registration statute is quite clear in its comment section that it was not intended to be punitive. It was not intended to be coercive. It was not intended to regulate interstate commerce. It was intended to provide carrots, inducements for a company to register in Pennsylvania. It wanted foreign corporations to register and tried to provide that carrot, if you will, the benefits that come along with it. And Norfolk chose to register under Pennsylvania law because presumably it wanted the benefits. They wanted the right to bring eminent domain suits.
But the statute says, I'm looking at 411A, that a foreign filing, et cetera, may not do business in this Commonwealth until it registers. How is that not mandatory?
Well, the business, I would argue, is the interstate business. It is not required to do business if it affects interstate commerce. I would first argue that. Secondly, how I would counter that is also the punishment for not doing business. It should register if it wants to do business. The punishment is not having access to the courts. And under that, Eli Lilly, that is considered a voluntarily, constitutionally permissible requirement upon foreign corporations if they want to perform interstate activity in Pennsylvania.
So you're saying, counsel, that it's not involuntary because the corporation still has the opportunity to choose whether or not to do business in Pennsylvania or through Pennsylvania?
Well, they've always had the opportunity to do interstate commerce in Pennsylvania, to run the railroads that affect interstate commerce. So that much, they always had the choice whether they registered or not. However, I would say that the registration allowed them to have the benefits of being a Pennsylvania, the benefits that come along with being a Pennsylvania corporation.
They chose that.
And they chose that. They voluntarily chose that. And as part of the statutory scheme, they also chose to consent to general jurisdiction. Now, I think now Norfolk regrets that decision, and they don't like that choice. But just as any contract you have with a party, any agreement you have, you give some, you get some in a contract, and that forms the agreement. Well, in this case, Norfolk decided to get the benefits of being a foreign corporation registered under Pennsylvania law, so they could have access to the courts, but they get some of the burdens that come along with it. And they have general jurisdiction. I want to also point out that just because Norfolk is subject to general jurisdiction, and you pointed in the facts in the beginning that the plaintiff is from Virginia, it involves exposure that happened outside of Pennsylvania. At the end of his career, he worked in Pennsylvania, but I don't believe, we haven't alleged that the exposure occurred in Pennsylvania, just to be clear. The defendant still has, under the Pennsylvania Rules of Civil Procedure, they can still move to dismiss a case in form of non-convenience. So this is not, all this statute does is provide general jurisdiction. It doesn't necessarily mean that the case has to be heard in Pennsylvania. In fact, I can imagine cases where, everything happened in Alaska, that case is going to be dismissed just because the defendant is subject to general jurisdiction. That case is going to be dismissed on a form of non-convenience. So the defendant is not without recourse here if the venue is oppressive and vexatious for them under the Pennsylvania Rules of Civil Procedure.
You comment on the implications of very recent U.S. Supreme Court precedent on this case.
Yes. So the Pennsylvania, or the United States Supreme Court in Daimler, Tyrell, and the international show, as they go on. You're talking about Daimler.
Goodyear and Daimler.
So the Supreme Court of the United States has found that you cannot compel an unwilling defendant to jurisdiction in a state where they have not either consented to it or under specific jurisdiction purposely availed themselves of that jurisdiction, sold the product, plus do other acts to get that product in that state where there's injury, or where there's systematic and continuous conduct. And I think under Tyrell or BNSF, Tyrell, the court specifically indicated that it would have to be a principal place of business or a state of incorporation, which was subject to the defendant to general jurisdiction. But those are cases where the defendant didn't consent to that jurisdiction, didn't desire to be in that jurisdiction, and consent to the general jurisdiction of the court. And under those cases, the Supreme Court decided there must be, to meet the traditional notions of fair play, there must be something that defendant did that put themselves into that jurisdiction, purposely sold a product in there and directed it to Pennsylvania. That would provide specific jurisdiction or incorporated in a state or its principal place of business. What those cases never addressed, and have always, I think the Supreme Court has always found, is consent to jurisdiction is always complied with due process. A party can consent in a contract. A party can consent by not raising personal jurisdiction. Personal jurisdiction is the defendant's right not to be hauled in a state to defend himself where it did not either do actions to subject it to. Those cases address those circumstances where the defendant did not choose to be in that jurisdiction. This is different in that defendant, when registering under Pennsylvania statutory scheme, in addition with the jurisdictional statute, consented to general jurisdiction. It's a different, I believe it's a different animal than Daimler and BNSF v. Tyrell. And I would also point out in Tyrell, the Supreme Court specifically, at the end of its opinion, said we're not addressing registration statutes in this. It wasn't, Montana had a registration statute that was raised at the High Court, and specifically, they said it wasn't addressed in Montana's opinion, and we're not going to address it here in the court. So I would, I believe those decisions do not affect consent.
Is there,
Let me take you back to the registration statute, because I find it confusing. Maybe you don't, but I do. So, the theory goes, because of subsection 11 of the provision in the statute that defines what is not doing business in the Commonwealth, which is engaging in interstate commerce, Norfolk didn't have to register to do business in Pennsylvania, because according to the statute, they weren't doing business in the Commonwealth, they were engaged in interstate commerce. Am I correct so far?
I agree with that.
Okay. So, if they didn't register, what is it that they would lose in terms of rights and obligations within the Commonwealth? And let me go on with that. I don't see anything in the statute that addresses businesses that engage in interstate commerce who do not have to register that would preclude them from bringing actions in Pennsylvania or otherwise engaging in the same rights and privileges that Pennsylvania business corporations can engage in.
I would agree if they're not required to register, then the inducements that were provided in the statute are they're not prevented from bringing lawsuits as well.
Okay, so if that's the correct interpretation of this statute, and I've not seen a whole lot of argument on this point from your opposing counsel, so I'm anxious to hear their understanding of the statute, but if what you just described, based upon my questioning of you, is the correct interpretation of the statute, by registering, that was a purely voluntary act. Purely voluntary.
That is my argument, Your Honor, that it is a voluntary act by the defendant that they made a decision based on information that based on, for whatever reasons that they have. And
but let me just bring this full circle, because there's a flaw in this theory, because if your interpretation is correct, and at least one reading of the statute would indicate this, they got nothing for registering. Because the exception 11 indicates that they are not doing business because they engage in interstate commerce. By registering, they got nothing because they would have had all the rights and privileges of the Pennsylvania corporation anyway.
Well, some of the rights, and we'd have to go through there, that they receive some rights under the Pennsylvania Individual Financial Responsibility Law. There are a litany of rights that they're entitled to if they register.
That they would not otherwise be entitled to. When they register, they are supposed to get the full rights and benefits, privileges that a domestic corporation in Pennsylvania gets. But like Justice Donahue, I'm not clear on what those are, and when you delineate those, are they in fact rights they would already get as engaging in interstate?
Right. The legislator, and I understand your question as to what rights, what benefit do they get from this registration statute. And my argument back to that would be they get the rights, they are a member of the Pennsylvania community. They are treated as a domestic corporation would have in this community.
Why would they care about being part of a community?
Yeah, and what are those?
The follow-up to my colleague's question is that the law says lists 11 things that do not constitute doing business. And the last one is doing business in interstate or foreign commerce. So every railway runs through various states. Why would any railway or basically any business, I mean, there are surpassingly few corporations which set out to limit their business to only Pennsylvania customers. I can't imagine a viable business plan that would say we're only going to sell to Pennsylvanians. I mean, what are we to make of this melange that the legislature has given us? So you can't do business in Pennsylvania until you register, but if you do interstate commerce, you're not doing business in Pennsylvania. How are we to make sense of this?
And if you do register, you're getting the full benefits and privileges of a domestic Pennsylvania corporation, but I'm still not clear on what those are.
And one word follow-up on that, based upon reading of the statute, if you're engaged in interstate commerce, you're going to get the full benefits of being a Pennsylvania corporation anyway, because you didn't have to register.
I don't know if I agree with that latter point. There are some areas that a foreign corporation can conduct business in Pennsylvania but not be treated as a Pennsylvania for certain circumstances, like maybe the benefits of the Pennsylvania Motor Vehicle Service Act. Also, and I'm not, there isn't a record before this court, and I think this is important, and it may address some of your questions. There's not a record before this court as to how this statute may have unfairly hurt the defendant. We don't have a record of Norfolk's, maybe perhaps interstate activity. Norfolk has not challenged this statute, the registration statute, that it unfairly prejudices them. They've made a frontal attack on the statute as a whole, that the statute as a whole is unconstitutional under the Due Process Clause. And these statutes, by this court, are presumed to be constitutional. So your questions as to what benefits they have, we don't have a record as to that.
I think it's a pure question of law. Can I just try to hone in a little bit on the questions from everyone? The 411B says the penalty for failure to register is you can't bring an action in Pennsylvania. So assume for a second that the railroad has not registered in Pennsylvania, except for your legal advice, and finds itself needing to bring an action in Pennsylvania. A deck action against a statute they don't like, a tax appeal, or whatever. Does 403A11, the fact that they're engaged in interstate commerce, mean that they can, in your view, bring an action in Pennsylvania, notwithstanding 411B? Follow what I'm asking?
I follow what you're asking.
And if not, then they do have to register.
Right. I think in addressing federal jurisprudence and reading the statute fairly, I believe that their activity that they're challenging was as a result of interstate commerce. They would be entitled to use the court system to protect those rights. What I think Pennsylvania has a right to is to prevent access to foreign corporations who are conducting solely interstate activity to access to the courts.
I don't know what that means, though.
Yeah,
What does that mean? I mean, in the real world, what kind of entity does the one and not the other? I'm not familiar with that. Certainly not a railroad.
Well,
the scale of this.
And Lehigh really involves sales of products in New Jersey solely for New Jersey companies and consumption of New Jersey citizens. And Norfolk, I would have to delve into their business model to answer your question as to what kind of conduct they would have as purely interstate. I mean, I agree they're a railroad that operates nationwide, and when they came into Pennsylvania and took over, in this case, it was Conrail's line. That's basically what happened. Norfolk and CSX split Conrail's lines. Conrail was a Pennsylvania company. They took over plants in Altoona and eastern Pennsylvania as well. And all I can say, I'm not sure I'm answering your question as to what conduct is interstate activity, but Norfolk made a decision. They wanted to be treated like Commonwealth in Pennsylvania. So they registered under the Foreign Registration Statute. Now, we can debate the merits of the law and whether the law is a good use by the legislator, but I think that would be within the that's the legislators decide the draft laws.
Well, we're not debating the merits, but we are debating, are we not, whether after Goodyear and Daimler, your position has any chance of prevailing under Scopus's view of jurisdiction, right?
Under Daimler, if I can address that again, I think there would be a problem if Pennsylvania said, if you're served in this state, you're subject to general jurisdiction because we served you in this state. Therefore, just based on the fact that you put an agent in this state and we served you, you're subject to general jurisdiction. This statute, whether we think it's a good statute or not, it doesn't violate any constitutional norms, and it does something different. It says, we're, number one, going to provide you the benefits of Pennsylvania law. Some might argue that that was a bad choice by Norfolk. But it also says, under the statutory scheme, that you're going to be subject to general jurisdiction. And that's what separates it from Daimler, Tyrell, and the Supreme Court cases, in my mind, is those cases they didn't deal with the statutory scheme that provided for consent.
Mr. Levin, we got it. And I think we're all hungry to hear from Mr. Mermelson because he holds the key to this. Your position is easy. You lose except they consented to jurisdiction voluntarily without coercion, not some sort of adhesive consent. They consented by registering when they didn't have to register, and therefore this takes it outside the scope of the U.S. Supreme Court.
That's correct, Your Honor. And, the burden is on, obviously, Norfolk to find the statutory scheme unconstitutional.
Well articulated. Thank you.
Thank you.
I think you understand the question. We're all anxious to hear the response.
I do, Your Honor. It may please the court, Bruce Meyers on behalf of Aplt, Norfolk Southern. And I want to address, I think I would divide it into two, although they're obviously related questions that the court has so far focused on in its question of my friend on the other side. And I'll start with the labeling of what's happening here, consent, and then I'll get into the question of was Norfolk Southern required to consent. The Supreme Court of the United States has repeatedly held, and most recently in the case cited in our brief, in Kuhn's case just 8 years ago, it's repeatedly held that a state may not condition the grant of a privilege or benefit, something it's not obligated to provide, something it chooses to provide, to allow development to happen at a particular location, or in this case, to allow foreign corporations to do business, and something that the corporation or the individual may voluntarily choose to do or not, to develop a property, to do business in Pennsylvania, that it may not condition the grant of that privilege or benefit on the waiver of a constitutional right. That is precisely, exactly as in Kuhn's, that is exactly what's happening here. Pennsylvania has said, you don't have to come here and do business, and I won't get into the fact that it's a little hard for a railroad not to do business in a particular place, but leave that aside, because there are certainly foreign corporations that arguably have a choice whether to do business in Pennsylvania or not. And so Pennsylvania said, if you want to come in here and do business, you must waive your right not to be subject to general personal jurisdiction. Let's be clear what that means. That means subject to jurisdiction here in Pennsylvania for any case arising anywhere in the world involving any plaintiffs having no connection to the Commonwealth, cases in which the Commonwealth has no interest. So you waive your right not to be subject to that incredibly broad scope of jurisdiction, which there's no dispute that Daimler and Goodyear have set forth. You waive that right as a condition of doing business in Pennsylvania.
I'm just trying to follow you, and I'm a little bit confused. What you're referring to is the statutory provision that's been in effect for decades is something that you have to comply with or agree that you're subject to in order to register to do business in Pennsylvania, but it's not mandatory to do business in Pennsylvania, and you can choose whether or not to register.
Well, you can't choose whether or not to register. I mean, I think Justice Weck, I won't go back over that, I think pointed out what I was going to say in response to the colloquy earlier, the statute is absolutely clear. If you are doing business, and I'll get into that in a second, if you are doing business as defined by the code, it says you may not do business until you register.
Right, but that goes a step beyond where we were, because you can choose not to do business in Pennsylvania. You can still have your interstate use, you can still have the trains go through all of these states, including Pennsylvania. You can choose not to do business in Pennsylvania and thus not register. That is your corporation's choice.
Correct. And my point is that the Supreme Court of the United States has said in Coons, just 8 years ago, in the cases cited there, that it doesn't matter that you have a choice. In those cases, a choice whether or not to seek a permit to develop your property. Nobody's compelling you to do that. You can choose to do that or choose not to. You can sell the property, you can do whatever you want. All of those unconstitutional conditions cases, leading up to Coons, but really all of the ones discussed by the Supreme Court in Coons, say the same thing. It doesn't matter that you have a choice whether or not to proceed with developing this property, building this home, or in this case, as Your Honor says, doing business in Pennsylvania. The state may not condition that benefit, that privilege, on the waiver of a constitutional right. That's what this court says.
But sir, it's not a constitutional right. The U.S. Supreme Court, in one of the cases, I'm not sure which one, had a footnote that said we're not discussing the question of registration and how it impacts on these cases. You read the sentence in the 411A saying may not do business in the Commonwealth unless it registered. But that's the way a layperson would read it, respectfully. You have to read the total statute. And the next section says the penalty for failure to register. And the penalty is you cannot bring an action in Pennsylvania. So if you're willing to forfeit the right to bring an action in Pennsylvania, then you have a meaningful right to not register. You can still run your interstate business through Pennsylvania. And that's the question before us, I think. Is your decision, is your client's decision to register absolutely voluntary, and therefore you can waive your right to a trial for a capital offense, you can absolutely consent to jurisdiction in Pennsylvania. And did you have a meaningful, open choice to consent? And if not, why not?
But, Your Honor, obviously this court ultimately will interpret the association's code. I will say respectfully, I don't think it can be read that way. I think that the code says in many places, in the language Your Honor just read, in other places, so Norfolk Southern, for example, is now registered. There's a provision on withdrawing that registration, which if this court concludes that it's not doing business in Pennsylvania, it's certainly going to do that. But that provision says you may not withdraw your registration unless you attest that you're not doing business. I would submit that the statute and the commentary is clear. You may not do business. You are violating Pennsylvania law. The penalty may not be you're going to be sent to jail, you're going to have an onerous fine, but you are violating the law if you don't register. In many other states, Supreme Courts addressing identical registration statutes have said the same.
Yeah, I'm not going to fight with you, but I have no mind on this issue. It's an interesting issue. As I read 411 A and B, and I read 40311 doing interstate business, it does seem that your client had a choice to register or not register. But what you're telling me is that they had no choice, they have to register. And therefore your answer is that this is not a voluntary consent to jurisdiction, but a coercive one that looking at these statutes, they don't mean what they say.
They didn't have a choice, and I'll get to that issue now. They didn't have a choice because they're doing business in Pennsylvania. And just to be clear, I think this is a threshold issue that's worth noting. Never before today has plaintiff challenged that fact. If you look at the response to the preliminary objections, you look at the Rule 1925 statement, you look at the appellate briefs, plaintiff accepted, and I'll get to why I'm sure that's the case because it's undisputed. Plaintiff accepted that Norfolk Southern is doing business in Pennsylvania. It obviously engages in interstate commerce, as do many of the thousands of foreign corporations registered in Pennsylvania.
So whether or not they're doing business in Pennsylvania, which may not be a subject of dispute, I guess what I don't understand is your position that they did not have a choice. Because they did have a choice only to do interstate business, right, which a railroad company obviously does, and that does not mean that they have to register. And that does not mean that they're doing business in Pennsylvania requiring them to register. That's where I'm missing.
So I'll go back to that question, Your Honor, and I'll just repeat what I said, which is the U.S. Supreme Court has made it clear that if the choice,
that's what you said didn't clarify.
if the choice is to do business, and yes, I will accept, again, I think for a railroad, I'm not sure that's the case, and I'll get into the specifics of that in a second, but I will accept for answering that question for present purposes that Norfolk Southern or other foreign corporations have a choice. They could say, we're not going to do business as it's defined in the code in Pennsylvania.
But we're still going to have interstate commerce.
Fine, but we're not going to do what the association's code defines as doing business in Pennsylvania. And the reason we're making that choice is because if we exercise our choice to do so, we have to waive a constitutional right. We have a constitutional right not to
apply to the statute.
Well, I'm not talking at this point about the registration statute, because the inevitable result of every single foreign corporation that registers to do business is they've now waived their due process right under Goodyear and Daimler not to be subject to general personal jurisdiction. That inevitably follows.
Yeah, so can I follow up on this? I think I'm trying to, and we have to really part of our frustration with this, because although this issue was briefed in 2017 by opposing counsel, Norfolk Southern never responded to this issue of the interpretation of our business registration law. So that's why we're struggling with this. I mean, as we're reading the statute, and as I said, I mean, this has been briefed on the other side. Because your client is engaged in interstate commerce under the Pennsylvania registration law, they are not deemed to be doing business in Pennsylvania and therefore don't have to register.
Well, one thing I will agree with my friend on the other side is there's no record of this. And the reason for that is because...
This is the law. I'm reading from the statute.
Well, but the statute, with respect, the statute doesn't say if you engage in interstate commerce and you engage in other things that are doing business, you don't have to register. So if Norfolk Southern is engaging in interstate commerce, which it obviously is, and again, as most of the foreign corporations registered to do business in Pennsylvania are, and is also engaging in intrastate commerce, is engaging in the things that are doing business under the association's code, it must register. And I think that's clear. If it's doing both,
I don't know if that's clear at all, counsel. Yeah. I mean, that's the problem that we're having. I mean, this is at one side of this issue has really not been presented to us. The statute says, 811, corporations doing business in interstate and foreign commerce are not doing business in Pennsylvania.
Well, again, what the statute says is the following do not constitute doing business. Right. And so, to the extent that Norfolk Southern is engaging in interstate commerce, that part of its operations in Pennsylvania is not, quote, doing business in Pennsylvania. Agreed. But the statute does not say, and if you're doing other things, as many interstate corporations engaging in interstate commerce are clearly doing.
But that's their choice to do other things, right?
Yes, but again, so now I'll answer that question, Your Honor. Their choice to do that is with a penalty, if they decide to exercise that choice, of waiving their constitutional right not to be subject to general personal jurisdiction.
I'm trying to imagine how that is a real choice. So, I mean, I guess we could engage in the fiction that a rail line is just a sealed train running across borders and nothing goes on in any state through which it passes. But in reality, you're going to be dealing with rights of ways and land acquisitions and a whole host of other matters in each state that you're passing through. So let me ask you this, are you aware of any railroad that doesn't register in the states through which it passes?
I'm not aware of it, Your Honor. And again, I would note, as I think I alluded to earlier, that many large international corporations that clearly engage almost entirely in interstate commerce, Google, Facebook, Microsoft, Amazon, huge corporations that nobody would say they're operating corner stores, mom and pop stores. They are engaged in interstate commerce as we currently understand interstate commerce. All are registered as foreign corporations in Pennsylvania.
Right, because otherwise they're not going to be able to buy and sell a building, enter into contracts,
Precisely. In fact, the commentary to the code that we're talking about, the provision we're talking about, says, as it's just one example of doing business in Pennsylvania, including of a company that's largely engaged in interstate commerce, is owning and using real estate for general business purposes. Norfolk Southern clearly does. It has facilities, it owns facilities, it leases facilities, it enters into local contracts. It does not have a choice whether to do that. But I think even if it was a foreign corporation that had a choice whether or not to engage in that conduct, again, Supreme Court precedent says you can't be put to that choice. That choice can't turn on whether or not you exercise it, you waive a constitutional right. If you don't exercise it, you don't get that benefit, you don't get that privilege. Yes, Your Honor.
The issue before this court is alleged that you are in the unconstitutionality of the statute that it's violative of due process. So our argument here today is involving 403 and 411, both the statutes in Pennsylvania, that you or counsel for Norfolk should be aware that you are involved in business through Pennsylvania. We all concede to that. The question I have is, even though you may not agree, our statute is very specific as to general jurisdiction. So you are on notice. Tell me, where's the violation of due process that our statute deprives you?
Well, because the Supreme Court has made clear that, as has this court, that notice and knowledge is inadequate, is insufficient to waive constitutional rights and due process.
And also, registration statute. Dollar is the case that the chief was referring to that has we're not touching registration. So our specific registration statute separates us such that if this were to appeal to the Supreme Court, I don't see a cert being granted because it's based primarily and specifically on Pennsylvania law.
Well,
not violative of any of the federal cases. So share with me where I'm wrong.
Well, because in order to waive a due process right, there's no question that this statute, and if the trial court reversed, that Norfolk Southern will be subject to general personal jurisdiction, so it can be sued in Pennsylvania for any claims arising anywhere, despite not being incorporated here and not having a physical place in business, which is its due process right under Goodyear and Dayton. It is essentially, plaintiff's argument is it consented to waive that right. That's plaintiff's entire argument. And to answer Your Honor's question, to waive a constitutional right, more is required than knowledge. It also must be voluntary. And it's not voluntary if you are put to the choice. And that's what the Supreme Court has said in Kuntz and in all the cases leading up to that. It's not voluntary. It said it is absolutely not voluntary if you're put to that choice. If you want to exercise your privilege, in order to do that, you must waive the constitutional right. You know that you're doing that. You can't just slap the label consent on that. That's an unconstitutional condition. That's what your court has held.
Position, sir, is, if I understand it, that you never had a choice but to register, and you put all of that on 411A, which says you may not do business in the Commonwealth.
I wouldn't say all of that, because the commentary confirms that, the withdrawal statute confirms that. That's certainly the linchpin of it, is that it says you may not. And if this court holds that that's voluntary, it's just a suggestion. I think what my opponent on their side says is that foreign corporations are encouraged.
As I said to you before, what I think this court could rule is if you look at B, penalty for failure to register, and you look at the next section, 403.11, doing business with foreign corporation, reading the statutes and criteria, that the consequence is that you can't bring an action. If you want to be at home in Pennsylvania, if you want to be the equivalent of domestic corporation, you make that choice. If you don't, the only thing that appears from what's actually before us and cited, and I have another question before I let you go, is that you can't bring an action. And again, that seems to be your choice.
Well,
and again, and you refute that, and again, we've been through this 5 times, we're not going to go through it again, but just want to be crystal clear, because we're going to vote right in just a few minutes. You refute that because I'm afraid you may not do business in Pennsylvania before 11A.
Yeah, I mean, there's 2 quick answers to that. I think that that a foreign corporation that is doing business is required to register, period. Yes, I think they are. But even if that's not the case, I think the penalty is not so small. I mean, the idea that you can't bring a suit for a dispute arising in Pennsylvania, and that it's not a fair exchange. If you want to be able to do that, you've got to give up your general due process, your general personal jurisdiction rights, and be subject to suit in Pennsylvania, even for activities not arising in Pennsylvania.
You have to agree to be at home in Pennsylvania. Let me ask you something before you conclude that is a little bit unusual and off subject. I think you raised it, and I think it's accurate. This did not come principally from the parties. I think there was an amicus brief by a Virginia law firm, if I remember correctly, and it raised this whole issue. And then I think one side did brief it at some point, the other side didn't brief it. Should we vacate, remand, give Judge New, who's a wonderfully gifted judge, an opportunity to look at this precise issue below before we try to take it apart and put it together? Or conversely, as a second potential, get from the both of you additional briefings so that you could articulate the withdrawal statute and this, that, and the other that supports you. So A, should we vacate, remand, and do this below? B, should we get more briefs? Or C, should we win?
I don't think you should vacate and remand. I'm always willing to submit briefs if the court believes that there's further argument that would be helpful. I think the fact that plaintiff accepted up until the point we're standing here today, the Norfolk Southern is doing business as defined in the association's code, means that the plaintiff should not get a second shot to basically prove it's not. I think that it will. I think if the record, Judge New, if it's vacated or remanded and there's a factual record developed, I think unquestionably it will be shown that Norfolk Southern is doing business in Pennsylvania.
It seems to me that we're not quibbling over a factual dispute. We're simply trying to address a legal issue.
And I agree. I think that there's a legal issue here as to whether or not foreign corporations that are doing business, and I believe that Norfolk Southern can be compelled to waive their due process rights and be subject to general personal jurisdiction as the price of doing business in Pennsylvania.
Right.
I think that's the issue before the court.
I agree. So if we were to order further briefing, I'm not sure what would it do.
And I think if you remanded, whatever happens in this case, and again, I think it will be clear, with factual development that Norfolk Southern is doing business. But whatever happens in this case, another case is going to come up, and maybe it involves a foreign corporation that unquestionably is just, acting in interstate commerce. I don't know, but the court will have to address this issue at some point.
So just so I'm clear about what my confusion is, a friend of the court raised this issue below. This issue was briefed in the Superior Court. Appellant briefed this issue regarding what the exception to doing business in Pennsylvania is under 1183. We've never gotten a response to that argument. So from my perspective, we're without the benefit of advocacy from Norfolk Southern on an interpretation of our business registration law. That's where my confusion on this issue arises.
But you were denied the opportunity to.
Well, I would say that we were. Certainly the amicus raised, and the amicus can't raise new issues as this court has held. The plaintiff discussed that provision, I think 411 or 403 that Your Honor has asked about. But again, I can't emphasize enough. Plaintiff never made the argument that Norfolk Southern was not required to register. They never made the argument that they're not doing business. Now,
certainly the entirety of the reply brief of the appellant was on this precise point. It was also made part of the argument in their original brief. And both of these things were before the Superior Court. At any point in time after this case was transferred to us, we could have gotten, at your request, a supplemental argument on this point. We just never got it. And I think what you're seeing from some of us is our frustration in attempting to work through the intricacies of the registration law, which, it's one of the issues in this case. If there is indeed valid consent because your client did not have to register, then we're in a different ballpark than if it was purely an involuntary requirement. On the other hand, the issue still remains, if Pennsylvania exercises jurisdiction in this regard, are we infringing on the sovereignty rights of our sister states to decide issues that are purely within the interests of those other sovereign states? Different issue, but what we have before us is a much broader and heretofore not spoken upon by this court or any other that I'm aware of as to what impact the registration statute has on the most recent jurisprudence from the United States Supreme Court.
And again, I would welcome the opportunity to provide further briefing if it would help. I would just follow up on Justice Todd's point, because I agree that the argument plaintiff made is the same one that was made here, the one that Chief Justice Behr has been asking me about, the question of whether or not registration is volunteer, even if a company or a corporation is doing business. I agree, plaintiff made that argument, and I thought we addressed that argument, I basically did not. I apologize. The argument that it was not required to, because essentially as a factual matter, it was only engaging in interstate commerce. I don't believe the plaintiff made that argument. I think the plaintiff in the trial court, through his whole 1945 statement and his appellate briefs, did not make that argument. I think that's a different argument. If it would help the court for Norfolk Southern to address either of those issues or both of those issues, we would welcome that opportunity.
Well, with respect to your brief, I think you allude to it, but your amicus brief, the amicus brief on your side by the Pennsylvania Defense Institute certainly drove home the mandatory argument. So, you know, it's not as if we haven't had sufficient argument on that particular issue, on whether it was mandatory.
Again, it seems that I would leave it to the court. You know, we would welcome the opportunity to provide any further briefing that would add clarity. I think that sounds like that's necessary, but obviously that's in the court's hands, and we'll wait word through the court on that.
All right, one of the difficulties with this now is that because the lower court found statute unconstitutional, clearly directed that we would argue the case. Typically, when we grant allowance of appeal, we frame a precise issue. That may, again, have caused some of the problems. Let us all discuss it. Thank you.
Thank you very much, Mallory.
Very well argued.
The next matter is Michael F. Szwerc, MD versus the Lehigh Valley Health Network. Representing Dr. Szwerc is Mr. Nicholas Fisk. Representing the Lehigh Valley Health Network is Ms. Kimberly Krupka.
We granted allowance of appeal in this case, and therefore we're able to frame the issue to consider whether the Superior Court properly concluded that a trial court lacked jurisdiction to consider the merits of petitioner's request for counsel fees and costs pursuant to Pennsylvania's wage payment and collection law, because petitioner was untimely in seeking that relief. Mr. Fisk, is it?
Yes, sir.
Go right ahead.
Good morning, Your Honors. May it please the Court, Nick Fisk on behalf of appellant Dr. Michael Szwerc. As I'm sure the panel is aware, the Superior Court in this matter determined that Section 5505 of the Judicial Code operated to basically mandate that a petition for attorney's fees is required to be filed within 30 days of what the Superior Court in this matter determines a final order under the wage payment and collection law. It is the appellant's position that that decision was an error and that one only need to look to the plain language of Section 5505 to determine that it's an applicable here. 5505 states, except as otherwise provided by or prescribed by law, a court upon notice the parties may modify or rescind any order within 30 days after its entry. The wage payment and collection law in this instance sets forth the explicit and exclusive procedure by which employees can gain mandatory attorney's fees, and expenses, and costs from an employer. The wage payment and collection law case. Accordingly, it is otherwise prescribed by law, and the first sentence of Section 5505 excludes it from its time provisions. And further, there is no modification or rescission of an order at issue in this case, such that 5505 again does not apply. A number of cases that have looked at this specific provision in the context of mandatory fee shifting statutes, both under the eminent domain code, and the Contractor Subcontractor Payment Act. In both of those instances, in one the Commonwealth Court and the other the Superior Court determined that 5505 did not apply by its terms for those same exact reasons. Accordingly, there was no 30-day time in which to request attorney's fees under the case. No court that we've been able to determine, and I think the same with Lehigh Valley and the underlying courts have found an instance in which this is applied to the wage payment and collection law, and I would submit that I have not seen a case either where it's been applied at all to a substantive fee shifting case to be found that.
So is it your position that you have an unlimited period of time to seek counsel fees?
That is not our position, Your Honor. This was an open and active case that was not final and involved the attorney's fees that were incurred on the first appeal in this matter and ultimately efforts to collect on the judgment. Yes, the judgment had been paid in October of 2018 it was, but the action was still open. There was no satisfaction or discontinuance of the docket. It was an active case, and as the court's reasoning in both Millvale and the Aplt case indicates, the case cannot be final until all attorney's fees issues have been determined.
When was the final, let's say, final order? Because I appreciate you can't take an appeal if you have a final order or judgment entered. And then, of course, it can be reversed on appeal, so the case goes on. But there reaches a point where we've decided the case, the U.S. Supreme Court has denied cert, and the case is over. Nobody's taken an appeal, this is another example, from a Superior Court decision, entitled appeal, therefore the case is over. So when was this merits case over? If you don't say, well, it's never over until you see counsel fees.
I wouldn't say that it's never over, Your Honor, but the prior appeal and the subsequent judgment in that instance involved the unpaid wages that were incurred in connection with the termination of my client and the attorney's fees that were incurred in connection with obtaining that judgment in the first instance. There has never been a final order with respect to the attorney's fees that were incurred on the appeal of this action.
So then the client keeps getting kicked forward.
On the merits of the case.
On the merits of the case, determining on underlying liability, yes, it was back prior to the initial appeal, which would have been
I think September 20th, 2018, does that sound right?
I would not agree with that. The underlying merits judgment would have been entered in February of 2017, and in connection with their first appeal, Lehigh Valley filed judgment on that award in March of 2017.
Can I follow up on the Chief's question about a limiting principle? I mean, it seems the can keeps, under your view of the case, keeps getting kicked. You reach for the can and you kick it while you're reaching for it, and you reach out and kick it again. So there's going to be an appeal, and there's going to be a collection effort. And I just don't know when the clock ever stops under your view of the law that we should be applying here. Can you shed some light on how we can structure this to articulate a limit? Because there does have to be a time when the clock stops, right?
I would agree with that, Your Honor, but that is the can continually getting kicked down the road in this instance is particularly why the 5505 is inapplicable to cases such as involving the wage payment collection law, where it's clear everybody, including the Superior Court in this case, agrees that the employee can recover their attorney's fees incurred on appeal in defending their underlying award. The entire purpose of the statute is to ensure that employers don't use the appeal process to strong arm or ultimately undermine the original award given to the employee. So here, the can does keep getting kicked down the road. We're going to seek our fees that are incurred on this appeal if we're ultimately successful in overturning the Superior Court's judgment, because that's what it took to get to a point where our client could recover wholly. When the case is satisfied and closed, that's when it ends. That hasn't happened here.
Your view of that would be after the attorney's fees litigation is continued. So you're in a circular argument. It never closes when you get counsel fees. And then once you get counsel fees and they're finally resolved, you get counsel fees in the next proceeding. Therefore, it never closes.
I wouldn't agree that it goes on and on forever, Your Honor. I mean, here we're talking about a delay of 6 months. This is not a situation in which years have passed. Although in Mill Creek, a year had passed in between when the final judgment was entered and the fees were sought. But here, the judgment was paid on the underlying liability aspect in October of 2017. It was perfectly within Lehigh Valley's rights and opportunities to mark the docket as satisfied and discontinued after that. They chose not to. The case was open and was not finalized.
But we all come from the real world of practicing law, and there's probably a majority of cases where parties settle, do a settlement agreement, at least in consideration, and nobody bothers to go to the fine and pay $5 and settle it on the record.
There was no settlement agreement. There was a payment of the prior underlying judgment with respect to the wages and fees that were incurred there. There was no resolution of the fees that were incurred on the appeal.
Let me ask you, I understand this argument. Are you arguing that we should treat the wage payment and collection law the same as Mill Creek treated the eminent domain code, and therefore create a exception to a general rule, or conversely, it seems to me you're arguing that the general rule is that 505 is never applicable, and that it's never over until it's satisfied on the docket after everything's done.
I would argue that you treat the wage payment and collection law like Mill Creek treated the eminent domain code, and like Capelli treated the contract or subcontract. And in those instances, those were active open cases in which someone submitted a fee petition, months or a year after the underlying merits of the case had been determined, and it was found to be timely. I wouldn't profess to tell you how to handle a case that was closed and someone sought attorney's fees 6 months after the docket was discontinued in a wage payment case. I think in order to be consistent, and it's my personal belief, the substantive fee shifting statutes are outside the scope of 5505. We haven't seen a case that actually applies it to any of those. And the only instances they've been applied are in permissive fee shifting circumstances involving vexatious conduct in underlying cases that had been closed. I'm not asking you to make a pronouncement about how this works in every circumstance, simply here, although again, my position is that those substantive fee shifting positions statutes are outside the scope of 5505.
Counsel, is your client entitled to costs of collection, attorney's fees incurred in collecting a judgment?
I believe that he is. I think
what does the statute say?
The statute says attorney's fees incurred in connection with, I think it says, of any kind in connection with the action. Again, going in with the spirit of what that attorney's fees provision is supposed to do, you shouldn't allow the employer to hold off on paying a judgment and then you have to chase it and then waste a bunch of time. I mean, in this instance, there have been numerous calls to Lehigh Valley to satisfy the judgment or the underlying judgment after the first Superior Court decision came down. Those were returned. We alternately had to do execution interrogatories on where we thought their bank was because we couldn't get any response from them in order to get them to pay on the judgment. So, they should be able to chase that. Those are not a substantial portion of the attorney's fees in this instance, but as a general proposition, they should be able to make us chase that and earn more attorney's fees.
Counsel, thank you very much.
Thank you.
I think it's still good morning, Your Honors. Good morning. My name is Kimberly Crookta, and I represent the Lehigh Valley Physician Group and the remaining Lehigh Valley Hospital defendants. I think it's very important that we focus on what the question was, and that was whether or not the trial court and thereafter the superior court improperly dismissed this case for both lack of jurisdiction and on the basis of lack of jurisdiction and overall that the motion was untimely. With no reason at all for its untimeliness. If we looked at the record here, the motion for attorney's fees was actually prepared on October 29th, 2018. It simply was not filed until April 4th of the next year. One of the questions Your Honor asked, I forget which one, was when did this case become final on the merits? This is a case where there was a motion for summary judgment with regard to approximately $71,000 of wages and benefits such as health insurance. After that motion for summary judgment was granted, there was a hearing on attorney's fees where the court ultimately determined about $389,000 worth of fees were incurred up to the point of the motion for summary judgment and the presentation of the fee petition. There was an appeal taken on that. There was an offer by Lehigh Valley to pay the entire amount if it moved from Lehigh Valley Hospital, the wrong descendant, to Lehigh Valley Physician Group. This becomes important later on that question of collection of the final judgment and delay. It was entered in the name of Lehigh Valley Hospital incorrectly. It should have been Lehigh Valley Physician Group. It's important for accounting purposes when cutting the check. That offer to pay the full amount was rejected. It went to the Superior Court. And on June 13, 2018, the Superior Court dismissed all appeals and cross appeals except for the fact that it said the award should be entered against Lehigh Valley Physician Group instead of Lehigh Valley Hospital. And in a perhaps awkward way, we remanded it to the trial court to do nothing further, but just have the correct defendant listed for the purposes of judgment. I would argue that the 30 days to file a fee petition should have occurred after June 13th, 2018. At that point it was final. No one took an appeal of the Superior Court's order, so no further action could be taken on that, and any fees incurred with that appeal were known as of that date and time.
Your opposing counsel indicates that he couldn't get the responses he needed to carry the case forward.
And Your Honor, if I can address that, because even assuming he is correct, we have a defense to that until the docket got marked as the correct judgment, we couldn't pay in and have the judgment satisfied. I could not issue a check payable by Lehigh Valley Physician Group until the judgment. But in any event,
but was that clear to opposing counsel? That it was the wrong party, that you couldn't draw a check on the wrong party.
Well, we knew that the court still had not changed that, and we negotiated a stipulation so that the court would accept the stipulation and change the docket.
So that wasn't a mystery?
No, that was completed on September 20th, though. We agreed on a stipulation that was presented to the trial court saying, please take these efforts to have the prothonotary change that docket so we can issue a check. The court granted that, the trial court signed that, and that stipulation was September 21, 2018. At that point in time, the prothonotary took its action, corrected it to make it the correct name, and judgment was paid on October 4, 2018. So my argument, if this court was to adopt either the majority or the dissent under Ness, the appeal fails. Because at that point in time, if you look at October 21, 2018, the docket was corrected. The stipulation was signed. 30 days thereafter brings us to approximately October 21. Even assuming you want to take it one step further, which I don't think the case law permits, but it would make no difference, the judgment was paid, and this is uncontested in both briefs, October 4, 2018. By October 4, 2018, the plaintiff had their money in their hands. They themselves, in their filings, prepared their petition for attorney fees on October 29, 2018. They simply did not file it or give any party notice of it until April 4, 2019. I think there, in and of itself, is proof that this additional time was not necessary. There was nothing they needed to know. That petition for attorney's fees was the fees that firm incurred. There should have been monthly billings. They would have known exactly how much they billed each month, what the fees were to the client. But they chose not to. And if we look at the trial court and the superior court, there's two things they find. One, there must be a balance between the right to recover by the appellants and the need for finality in litigation. There's no appeal. The docket's corrected. Payment is received. That all happened September, October. Nothing additional occurs. And in addition, both the trial court and the superior court say if you look at 5505 of the Judicial Code limits, it limits it to 30 days. And while it is true that there is no true fee-shifting statute, and I'll submit either way that says it has to be within 30 days or it can be longer than in 30 days because Capelli and Mill Creek are absolutely distinguishable when we look at them. What we do see is...
May I ask you, is Mill Creek properly decided? It's not our case, it's not binding on us.
Well, Your Honor, if we look at the language of Mill Creek, I think we have to look at the very end. The court notes, and I'll quote, in any case, so unquote, if we go back, they say, you know, the eminent domain code is the exclusive remedy. The eminent domain code provides for appraisal, attorney, and engineering fees, so it's actually different types of fees. But after it makes that analysis, it says, in any case, we discern no error in the trial court's holding that the final order in the eminent domain proceeding was its July 16, 2014 order, that the deed held by the township revests, I think means revert to the trust. If we look at Mill Creek, what happened was the petition for attorney's fees was actually filed before the final order in the case because although the motion to leave was filed on October 12th, 2012, and the fee petition was filed on October 23rd, 2013 in Mill Creek, while the fee petition was pending, the trust filed a petition for decree reinvesting title into the trust in July of 2014. So it's interesting, in Mill Creek, the court goes through all this analysis of why the fee petition is not late, but then says in any event, it doesn't really matter because there was still more happening in the case, the reinvesting.
That's right. Go ahead.
Counsel, all of this is only relevant, this timing in 30 days, if what we're talking about here with this fee petition is actually a modification of an order. Is this not a request for attorney's fees based upon the occurrence of circumstances post-order? It's not really a modification of the trial court's original order in the case.
Your Honor, I think the case law, though if we look at it, has applied 5505 to orders for petitions for attorney's fees. If I can, what happens is 2503. There's a subsection 9. This is the right of participants to receive counsel fees. Subsection 10 addresses the right to receive counsel fees when the statute permits it, and I would argue this is a statute that permits it.
5505?
Well,
WPCL.
Because I don't see the applicability of 5505 rule.
That my question is, let me piggyback on Justice Thomas' question. Counsel sought fees pursuant to the wage protection payment collection law. That statute is silent as to the time requirements. There's no ceiling. 5505, it says, as otherwise prescribed by law. The first sentence of 55. So we already have the law, which is the wage protection collection law. So share with me why we need to consider 5505 when it specifically says, don't look at me if there's another statute that deals with counsel.
Well, and even if it didn't say that, I don't know how you come under 5505.
But that would be secondary to the modification argument. I'm still trying to understand how you're focusing your argument on 5505 when the very first sentence indicates it's not to be considered if there's another statute for which counsel has used.
yes, right. So to address that, 5505, the introductory clause does say, except as otherwise provided or prescribed by law.
Right.
However, if we go to 42, section 2503, it enumerates the instances under when fees can be awarded, which it includes when it's permitted by a statute. There's 10 instances. Of those instances, number 9, for instance, and number 7, the court has continuously applied 5505 to it. So when fees have been permitted under 2503, which includes by statute, and the statute itself does not set forth a time.
But subsection 10 of 2503 says any other participant in such circumstances as may be specified by statute heretofore or hereafter enacted. Why is that not the exception rolled back to WPCL?
But, and it says the following, that section goes, the following participants shall be entitled to reasonable counsel fees as part of the cost of this matter, and then it lists these instances, which I would indicate number 10 is the statutory WPCL. Right. So what I'm saying is when we look at those 10 instances, when the court had to look at, for instance, number 9, counsel fees because of the conduct of another party. When the court was looking at awarding fees under 2503, now it's a different subsection, subsection 9 versus subsection 10, the court relied upon 5505. It did it in Ness, it did it in, when we look at Capelli, when we look at Mill Creek. Mill Creek was one exception because it said that the recovery could only be under the eminent domain code. I would indicate there was another way to obtain recovery. It wasn't only under the Pennsylvania wage case.
The Superior Court cases and Commonwealth Court cases. We're the Supreme Court.
Right.
What is your prejudice in the 6-month delay? And are you in fact asking us to remand this for a recalculation of attorney fees, excluding the amount of monies that may have been attached as a result of the judicial delay caused by the indication of the wrong file?
Your Honor, we're asking that we absolutely are asserting that there is a prejudice. When a court, and that's one of the things the lower court looked at as well, there is a need for finality in this case. And in this case, one of the things the Judge Rightly, at the time he was sitting in civil court again, one of the things they look at is reasonableness of attorney's fees, the number of hours that are appropriate. In this case, at times there were 4 and 6 attorneys reviewing a brief and billing for that. There was 1,450 hours to just get to motions for summary judgment. So we definitely would be arguing the reasonableness of the number of hours in this case that were presented. But when that's judged with, there's absolutely no reason for a litigant to delay in the case. I think we can look at Ness, which talks about when attorney's fees.
Other than the statute doesn't prohibit it, and what you're arguing about, the reasonableness, only comes into play if it's before the court to evaluate. So I'm confused. The question really becomes how, let me rephrase it once again because I don't think you answered me. How is 5505 applicable when we have a specific statute that's permitting reasonable attorney fees with no time restrictions? And the case law that you cite permits a 1 year delay, and where counsel is only one half short of that.
I'm not sure I cited any case that permitted a 1 year delay.
Mill Creek.
Well, I think in Mill Creek, the
There was
difference.
a delay of 1 year, correct?
Your Honor, that's not how I interpret Mill Creek.
Okay.
What happened in Mill Creek is the case was still going. In fact, they filed their fee petition in 2013, and then they filed for a reinvestment of the title in 2014. And that's why at the last paragraph, the court said it doesn't really matter what we said in the paragraphs before because this case is ongoing.
But in Mill Creek, the court did say, did it not, that because it's under the eminent domain code, that's distinct from 5505, which, again, is not a great vehicle for counsel fees, but that's the practice that's going on in Pennsylvania. And because it's under the eminent domain code, there's no time limit. Even though you can justify its decision on an alternative basis, that is in there, and it would seem that the law in Pennsylvania, right now in some trial court, is if you have an eminent domain code request for counsel fees, you're not limited by 5505.
One of the questions you first asked me was Mill Creek judged incorrectly.
Right.
And that's a difficult question because I'm not here on the eminent domain code. I think the eminent domain code says it's the exclusive remedy for certain things, whereas collection of, if an employee has options other than the Pennsylvania wage payment and collection law, they can sue under, this was a contract case, in fact, it was an employment contract, so it is not the exclusive remedy for an employee. As far as Mill Creek, I think if we look at the reasoning in Ness, it would have been a better reasoning, which is, I'll even accept the dissent in Ness, because that's the furthest it went, was to say, it is really perhaps difficult to know what your attorney's fees are on an appeal before you do the appeal. So that's why the court in Ness said, well, the dissent in Ness said, but at least do it within 30 days of the appeal being final, because you know what your fees are. And if I can, one of the statements was that Capelli was a Pennsylvania Contractor and Subcontractor Act, and somehow Capelli stands for the proposition that the plaintiff indicates. There was a difference in Capelli. When the court reported the verdict of the jury, the plaintiff said on the record, Your Honor, I want to file a fee petition. I want to assert fees. So the right was preserved right there. And the court said, okay, speak with my court staff and schedule a hearing on the issue. And what Capelli found was not that you can file it at any point in time. My understanding of it is as long as you seek your attorney's fees, you file your petition, you get the hearing with the judge, the court can take longer to decide it.
Now, so can I go back to my original question, and I'm still struggling with this. 5505 only applies to a modification of an order. As far as I can determine, taking into consideration the purpose of this statute, this isn't a modification of an order at all. This is an award of additional statutory damages. It's not modifying the underlying order in any way, shape, or form. It's a new order. And so, I understand you saying there has to be some time limit, and I think that's what Chief Justice Behr suggested earlier, and Justice Szwerc, who was kicking the can down the road, was suggesting earlier. I think what's before us is whether 5505 applies here. I mean, and that's what I'm struggling with. I just don't see how this is a modification of an order that comes even remotely under the purpose of 5505. Maybe there's a 30-day limit, but it's not because of 5505.
Your Honor, I looked at the same issue because I understand that that was brief. So I'm preparing for today. I did examine the issue of how is this a modification or rescinding of the order. What I found was the best response I can provide to you is the court in Ness, even though it was not rescinding or modifying, it was doing a new order. It was a issue for attorney's fees. It still applied.
Because that award was based upon vexatious conduct by a litigant. In the action on which that order was entered, it was a penalty. It was a penalty for conduct involved in the action in which the order was entered. That's not what this is. This is a statute that says, in order to be made whole, you get all of your damages, which includes attorney's fees on appeal. So I'm just struggling with how you can be required to request a modification of a trial court order when what you're asking for are damages incurred as a result of the appeal.
My best response would be that once the Superior Court entered its final order on the merits, the final order in the case, 30 days elapsed, that the whole case became final. No action was taken. And there has to be some finality. The wage payment collection law is silent on that point. Does that mean it's 1 year? Does it mean it's 4 years?
That's my question. That's my next question, counsel. You seem to be faced with a court where some of us obviously are at this point of the view that you don't come under 5505, and at least one of us is under the view that if you go in the door to 5505, you get rejected because of the introductory language. If the court determines that 5505 does not apply, then what is the time?
Your Honor, I would suggest it's 30 days either after the final order is filed, so it's consistent.
Based on what?
Well, Your Honor, because there is no, I would suggest if the court was to impose 1 year, 2 years, 4 years, it would need to make something up because it's not in the act.
What about latches? What about it's allowed unless latches is demonstrated?
Well, you know, I'm not sure that in this case the court can make a determination about latches. I would say the fact that the petition was prepared in they put in their fee petition that it was prepared in October but not filed to April. I'm not sure why. That's latches in my view. But my suggestion would be the court would have to be making up a time because it's not spelled out. And if the court was to set a time, it seems most consistent to do what it does in other cases, which is once you have a final order that can no longer be appealed, the Superior Court order, perhaps in this case, because no one took appeal, was final. Then within 30 days, file your fee petition. Or at least within 30 days of receiving your money.
You do that by analogy to all the time limits in the law. And, you know, and I think some lower court judge was struggling with counsel fees. Our law just is not very clear, our procedural law on how to do it. And they grabbed 5505 because they didn't know what else to do. And perhaps you, or perhaps one of us, should write to the Civil Rules Committee and they should take a look at how you get counsel fees and when you get counsel fees.
And I think the trial
But that leaves you at a disadvantage standing here today.
But I do think the trial court did it on 2 issues. If you look at the trial court opinion, one, they found it on the issue that they lacked jurisdiction. And on 2, the trial court also found that, in their words, there has to be a balance. And they were balancing that, perhaps doing that latches argument. And that's not the question on appeal, but one of the findings for rejection of the petition was because of the balance of the right to recover and the need of finality.
Your position, and we got it, is that there needs to be finality. It can't, it's an absurd proposition to say you do this 5 years later. Indeed, plaintiff doesn't even make that argument. He just says his petition is soon enough.
Well, and Your Honor, he indicated that should this case end in his favor, he's going to file another fee petition, but I don't know if that's going to be in a year, 3 years, when I can close the case.
Thank you very much to both sides. Let's take a 45 minutes. Is that enough time? 45 minutes break, and we'll hear the final two cases of the day. I apologize for not telling you earlier, but frankly, the arguments all went a little longer than I would have guessed. Thank you.
trial court order which granted a new trial in a medical malpractice case because defendant's counsel directed a question to defendant's expert witness regarding plaintiff's alleged inability to find an expert. At post-trial motions, the trial court determined defendant's question was so improper and prejudicial as to require a new trial. The Superior Court affirmed, finding that the record supported the trial court's factual and legal decisions. This court granted an allowance of appeal to examine whether the Superior Court misapplied Pennsylvania's settled standards for determination of prejudice caused by statements or questions of trial counsel. With that, Mr. Hare, representing the appellant, feel free.
Good afternoon, Your Honors, and Mr. Haynes. May it please the Court, John Hare for the defendants, Dr. William Meyers, the Vincere Institute, and the Vincere Corps physicians. Your Honors, as the Chief Justice summarized, this case involves the standard for determining when the inevitably strong language and comments of attorneys in the heat of trial are so improper and egregious that they require overturning a jury verdict and awarding a new trial. Unlike so many civil cases that come before this court, this issue is not a partisan issue, obviously, because lawyers on both sides have an equal interest in being able to zealously represent clients. This court has said that it wants lawyers to be what the court has colorfully called forensic fire eaters and champions for justice in the courtroom. And those are colorful descriptions, but they make the point that trials are serious. The stakes are big, as they were in this case many times. And so we want lawyers to be as zealous as possible unless they cross very clear lines and say things that are obviously improper. Courts simply have not awarded new trials based on a single word or phrase, and that's what happened here, because defense counsel said couldn't find instead of didn't find. We don't do that unless that single word or phrase is something like collateral sources in this court's Heilman case, liability insurance, a vicious attack on the character of an opponent, violation of a court order, or the final category is really what I'd call complete lies. The Superior Court Siegel versus definition case, this court's decisions in Factor and the Rice case, nothing like that happened here when we consider the full context and content of what defense counsel said. And if I could just spend a minute on context. Classic medical malpractice case, 2-week battle of the experts. The central, if not sole issue in the case is whether an attending radiologist properly reads a musculoskeletal MRI. Plaintiff's an NFL football player. It's a core muscle MRI. And the whole question is whether it shows scar tissue or it shows a tear, as the attending radiologist found. Despite that, the importance of that radiological slide here, plaintiff doesn't call any expert in musculoskeletal radiology or even radiology. And I know counsel has an explanation and he offered it to the jury, but no expert in radiology in a case that's all about radiology. The defense, on the other hand, calls 2 highly qualified musculoskeletal radiologists, one of whom, with the defendant in this case, had developed the protocols for doing MRIs like this, and the other also was a doctor who worked with NFL teams. So because he didn't have his own expert in musculoskeletal radiology, plaintiff's counsel employs a strategy of diminishing and demeaning the field of musculoskeletal radiology. With the first expert, he says, isn't this just a self-declared field? Because there's no board certification. Any of the thousands of radiologists who think, as counsel put it, they can read musculoskeletal imaging can call themselves a musculoskeletal radiologist. So defense counsel gets up on his feet with the very next witness, next morning, but he's the other musculoskeletal radiologist. He says, okay, of these thousands of radiologists who can allegedly do this, did you know that plaintiff couldn't find one to come into the courtroom to support the attending radiologist? That's the context for the statement.
You know, Mr. Hare, we don't typically, I'm hesitant because we don't typically get into facts. But it does seem in this area of the law that the reprehensibility of counsel's comment plays some role in trial judge's decision. And you didn't try this case, obviously, I know that. But the lawyer who did try this case, when he asked that question, was aware that plaintiff, in fact, had an expert who had submitted an expert report and was on the witness sheet. I think it was a Dr. Chekhov. So it makes it look, aside from all the legal issues we can talk about, it does look as if it was an intentional misrepresentation built into the question.
Yeah, Your Honor, counsel did say couldn't find in a 27-word question. In fact, it was the defense position at trial that this radiologist that he identified but never called, because we're in the defense case by the time the question's asked, didn't actually support the attending radiologist. He found a partial tear. The whole thing was whether this was torn off the bone so this athlete could no longer continue his career. But I appreciate that's factual, Your Honor. I believe to do what the lower courts did, to just focus on the word couldn't, because the Superior Court said if counsel said he didn't find one, that would have been fine. But saying couldn't find one was over the line, and that's why I started with the context, because this court has repeatedly said, even if it's otherwise improper, a fair response to a really strong argument from a lawyer doesn't justify a new trial. We've cited dozens of cases on this issue of when comments do or don't require new trials. The closest one, I think, sorry, Your Honor.
The fact that Dr. Chekhov was one of the witnesses, share with me, my understanding of the record is that the record is absent as to the introduction of that expert to the jury, correct?
That is correct, Your Honor.
So therefore, I guess the question I have, and I'm going to ask counsel, is where's the prejudice or the removal of credibility when the jury was not presented with any evidence that there was even no Dr. Chekhov?
And I agree with that, Your Honor. I just would like to say something, because I'm not going to have an opportunity for rebuttal. The trial court says that plaintiff's counsel referenced him in opening statements. That is completely wrong. Defense counsel referenced defense counsel's own expert. Yep. Okay.
I'm looking at the issue of the evidence. The issue here is what caused, did this comment take away the credibility finding from the jury? I need to ask you, what is the issue before the jury regarding experts for counsel?
Yeah. I agree with you. I don't think there is an issue, Your Honor. Nobody took away credibility. The expert wasn't referenced. Despite that, among her many curative measures the trial judge took, she gave plaintiff the opportunity to stand up in his closing and explain why he didn't call a radiology expert. He said, I called the attending who's board certified. I didn't need an expert. So counsel fully had the opportunity to explain that. And he also said, with respect to this issue that couldn't find meant he couldn't retain anyone in the world, counsel fully understood at trial what he was being criticized for, not calling an expert, because he said to the jury in closings, I know I've been criticized for not bringing an expert in. Everyone knew at trial, which is I think why the trial judge denied a mistrial and only awarded a trial later, but there was no taking away of credibility, Your Honor.
Mr. Hare, am I correct that the attending physician, the attending radiologist who was called, who was board certified, was only called as a fact witness and not an expert? That
is correct, Your Honor. And it's crucial, that point, because what defense counsel said is you didn't call anyone to support him. It was his interpretation that was challenged by not only the defendant, and I'm not telling you this to impress you, this man invented, at least pioneered the modern field of core medicine, which is why Chicago Bears come to Philadelphia, which is why professional athletes all over the world come here. So you have the testimony from this guy, two leading radiology experts, about whether the attending's read is correct. So counsel says you didn't call anybody to support him. So the jury evaluated this when counsel said, I didn't need him. I called a board certified attending radiologist, and then without any support, which was the whole point of defense counsel's comment.
Can I, it's a little bit off the subject, but Justice Todd raised it. I didn't understand at all how Dr. Reed was a, quote, fact witness, end of quote. The facts he gave were not the kind of facts that a layperson would give absent expertise. In other words, if Dr. Reed was called to say the red car ran the red light, I get that. But he was called to say that the MRI showed a complete tear of the abductor muscle. That's an expert opinion. I don't understand the whole nomenclature of fact witness. Seems to me his testimony was that of an expert witness qualified to provide it.
Yeah, and I agree with you, Your Honor, that certainly reading an MRI is beyond the knowledge of a lay juror, but in the context of medical malpractice cases, testifying about a medical finding, if you are a treating physician, which he was because he actually read the MRI that had been done, in that context he is a treating physician. But I just return quickly to this idea of a fair response, because the closest case of anything that anybody has discussed here, I think, is this court's decision in the Martin case, where defense counsel criticized plaintiff, factually similar, for not calling a medical doctor. Plaintiff's counsel stood up and said, well, the defense corporation is rich enough to do that, to call the doctor himself if it wanted to. This court said, of course that's an improper statement, but it's a counterpunch. It's a response to aggressive trial lawyering. It doesn't justify a new trial. Just a few years ago, this court said that a prosecutor can call a defendant a cold-blooded killer despite prior case law about whether that's proper, because the defendant interposed a defense that he acted in the heat of passion. That was the Clancy case. And so here, when the whole argument is this is a made-up specialty, it's a fair response to say, okay, if that many people can do it, why didn't you call somebody? In addition to the fact that credibility wasn't in play, I'd just briefly mention all of the measures the trial court took to deal with this. The objection is immediately sustained before the question's answered, even when defense counsel tries to repeat the question. The court issues a curative instruction. Unusually, she gives plaintiff the opportunity to present a rebuttal case. And he does, but he only calls his plaintiff, not this expert who he allegedly retained before trial. And I appreciate the response might be, well, I couldn't get him there in a couple days, but that tells you he was never going to call an expert to support this attending radiologist.
Well, he wasn't allegedly, right? He was contacted before trial?
He attached a report, Your Honor, but I only suggest that he's alleged because it's extremely curious in a case that's all about radiology not to call an expert. And I believe it's because he didn't support. He said it's a partial tear, which would have been critical in this case. So he definitely retained him. I just, to say alleged that he would have supported Dr. Reid. We don't know because he wasn't called.
I understand.
Yeah.
Mr. Hare?
Yes, Your Honor.
In your view, did Judge Bose, in her dissent, ably capture your position on appeal?
I do, Your Honor. I think she said it, as usual, much better than I could have.
It says, by focusing solely upon the verb utilized by the defense counsel to the exclusion of all other substance, the majority has mischaracterized the basic import of counsel's question. Counsel's statement betrayed no misrepresentation, but drew valid attention to the indisputable fact that Aplt had not presented expert testimony regarding the correctness of Dr. Reid's interpretation. Is that the sum and substance of your argument?
It is, Your Honor. Thank you.
Counsel, if I might,
sure.
if I might ask you a couple of questions. Would it have been within the trial court's discretion to allow a mistrial?
Your Honor, we wouldn't have been able to challenge it because then, it's only the grant of a new trial that's appealable, but I don't think on this record that it would have been a proper grant of a mistrial. I think she had discretion to do it, but I think that it would have been an abuse of discretion.
And she decided she made a mistake by not granting a mistrial.
She did.
As I understand the record. And wasn't the trial judge in the best position to determine the effect of the line of questioning at issue here?
Yes, initially, Your Honor, and that's why she has discretion. But I'd point out a couple interesting things.
Well,
I'm sorry.
Where does it stop? I mean, initially, that's what I'm groping with here. I mean, I think Chief Justice Baer said we very seldom get involved in a case like this that, frankly, could have gone either way. I mean, in my opinion, and I'm struggling with what it is, what line in the sand we're drawing here. I mean. This question, I don't know, arguably suggested that 5,000 experts disagreed with the plaintiff. I mean, is that proper? I don't know. That's what I'm saying. The trial judge sat through this case and, ultimately decided what I did didn't fix this. I should have granted a mistrial here.
Yeah. Your Honor, if I could, this is an unusual area of the law because we've cited, I think, 30 or 40 of these cases. The majority overturned trial court discretion on this subject of whether comments require new trials. And notably, almost all of the big cases, this court's Factor and Heilman decisions, Young versus Washington Hospital, Justice Todd, Ferguson, Justice Wecht, as Superior Court judges, Siegel versus definition, Powles v. Hilton, the cocaine case. Every one of those cases overturned trial court discretion, because I think that while trial judges have discretion, certainly because they're contemporaneously observing, there's now a record from which we can evaluate against the context of all these other cases whether discretion's abused. And what's interesting here is the judge watching it contemporaneously 6 days before the verdict, by the way. This question 6 days before the verdict, didn't think it required a mistrial. So she has discretion, but I think a factor that you evaluate along with all these cases overturning exercise of discretion is that she didn't contemporaneously observing it feel that it required a new trial at that time. So I do think she abused her discretion. I think there's lots of cases suggesting that trial judges doing things like this do abuse their discretion because this is just fair game at trial.
For a different standard, interesting. If I could follow up on that, do you suggest that we should articulate a different standard when a trial judge applies her discretion in the first instance to motion for a mistrial, grant or deny, than to what happened here, where she in effect reconsiders her earlier decision? Is there some intelligible or principled way in which we can differentiate the standards to look at those?
Yeah, in fairness, Your Honor, I think it's still an abuse of discretion standard. I just think the fact that contemporaneously observing it, which is why she had discretion, she didn't grant a mistrial, is a factor along with all of these other curative measures that the court would consider in saying she did abuse her discretion. So it's the same standard.
Though, Mr. I'm sorry.
No.
I apologize for interrupting you. It seems to me that point cuts against you. You have a question, at least arguably, there was no foundation for it. It assumed facts, not in evidence. It was an attack to some extent on the credibility of Dr. Reid. And I was a trial court judge for a long time. I think I would have thrown the papers in the air, declared a mistrial, and walked off the bench. But that was my impression when I read it. So that's why I'm asking about what Justice Wecht asked you. I think the trial court didn't, I don't know, you were 6 days into a trial, judicial resources, she tried to go forward. Then at the conclusion, she said, I blew this. That was such a prejudicial question that I should have granted that mistrial then and there. And even though this is a very difficult thing for me, I have to correct my error. Why isn't she within her discretion to correct her prior mistake at that juncture?
Yeah, Your Honor, I agree that trial judges have the discretion to do that when it's appropriate. But this court, of course, has a review function. And I believe that's an abuse of discretion for all of these reasons. You know, judges have discretion to reconsider trial rulings, of course, in post-trial motions. That's why we have that process. But when you consider what happened here, that this was a direct response, a fact that's never mentioned in any of the trial court or the Superior Court analysis until Judge Bowe's dissent. Counsel was responding to a really strident argument that the defense experts made up their subspecialty. That's a fair counterpunch in the
We'll have to read the record to find that, too.
No, I appreciate that.
Counsel,
Sure.
let me follow up on that because Judge Bowes is an exceptional jurist in my opinion. But to suggest that this was a response to unprofessional questioning by opposing counsel when the trial court never made such a determination or even inkled. As a matter of fact, it was to the contrary. The trial court decided that there was, she had made a mistake in the first instance. I mean, this notion of fair response to tough questioning, I don't know. I mean, Judge Bowes had her opinion of a cold record. The trial court judge had a decidedly different perspective of being in the courtroom and the reaction to it. So a fair response, if you can, explain to me how that fits into the context of what the trial court's reaction was to actually seeing this in progress, I would appreciate it.
Yeah, I think, Your Honor, Judge Bowe's first point was focusing on 2 words of a 27-word question completely distorted what the question was. So that is an argument or a position from Judge Bose that the question wasn't improper. When you take it as a whole, as counsel acknowledged in his closing argument, he was being criticized for not calling an expert. And then you get to, is the question so improper it requires a new trial? And that's where the fair response doctrine comes in. Like saying, you're so rich, you could have called that expert if you wanted to, or he's a cold-blooded killer, standing alone, it's improper. But when you put it in the context of what he's responding to, it doesn't then require a new trial. And I think that was her point, because this is a great example of forensic fire eating. Two very well-known, very type A lawyers going at it at trial with all love and respect, and he won't deny that. That's what this trial was about. And so the judge, I think, at trial had it correct, that it didn't justify mistrial. This question 6 days before the verdict simply didn't have an unavoidable effect of rendering this jury incapable of rendering a fair verdict. And I think that's the standard, Your Honors.
That is the standard. So you do champion the unavoidable effect standard.
It's interesting, Your Honor. That's uniformly used in criminal cases. It's sometimes used in civil cases. The Superior Court here talked about tendency to influence. So all we've suggested in our brief is, for the sake of uniformity, if it's sufficient to protect criminal defendants, why not use this unavoidable effect, rendering a jury incapable standard? And it's really more verbiage than substance, I think, but that has its uses. Thank you, Your Honors.
Thank you. Thank you. Mr. Haynes?
As my career goes on, I labor about the propriety of a trial lawyer arguing his own case before an appellate bench. But this is a somewhat unique situation for a variety of reasons. And if you'll indulge me a minute, I'd like to give you some context of this, because at the end of the day, I believe the context is critical. Craig Steltz was treated by Dr. Meyers. It is Dr. Meyers' negligence that Craig Steltz challenged in this lawsuit. The medical records produced in this case, introduced in this case, and admitted to by everyone contained not one word about Dr. Zoga. Does not mention that Dr. Zoga did an interpretation of this film. Does not indicate anything about a conversation between Dr. Zoga in Massachusetts and Dr. Meyers. The only thing in the medical records is a single report from Dr. Reid, who was the radiologist assigned to interpret the MRI, in which he reported a tear. Pretty straightforward from the records. But the trial turned into a very different exercise, because now the jury learns, oh, I didn't know anything about it, Dr. Reid. Who's Dr. Reid? I looked, this is Dr. Meyers. I looked at the MRI. I called Adam Zoga on the phone, and he had the MRI, and we talked about it. I had no idea there was a report of a tear. Now Adam Zoga becomes the focus of this trial. Adam Zoga is called by the defense. There are 25 pages of his credentials introduced to the jury. About half of those pages are how he and Dr. Meyers are the, and this is the defense word, the go-to people in the world to treat, to diagnose and treat this injury. Well, here we are. Dr. Zoga says, I did the interpretation. I'm the guy. end of subject. I.e., Dr. Reid's just a backbencher. He's second-team guy.
Dr. Meyers is the defendant doctor. Dr. Zoga was his expert. Is that right or wrong?
He was
one of his experts.
He late in the game, he was identified as an expert. Yes, that's correct.
Respectfully, Mr. Haynes, it's no criticism of the defense case that they called an expert that they thought highly of.
Oh no, I'm not suggesting that, Judge. I'm suggesting not that they called Dr. Zoga as an expert, but now the story is Dr. Zoga is the only person that can interpret this MRI. That's the context in which this issue comes up.
And again, that's just argument.
Counsel, the issue I have here.
Pardon me?
I'm finished.
No, you go ahead.
Yeah, you can answer.
I'm not sure there's a question. I was not quite finished.
I have a question.
But go ahead.
The question is, the issue here today is your challenge, or the hospital's challenge, that you didn't call an expert witness. That Dr. Reid, by your own admission in your own brief, was a fact witness. You had an opportunity to call your fact witness, Dr. Checkup, but that Dr. Checkup was never made known to the jury in any shape or form. So as far as this record's concerned, they had no knowledge or approval. You, through your introduction of your witnesses, shared with the world and the jury that your presentation of Dr. Reid, that he was the best. They rebut with, or they put their defense on. You have an opportunity for rebuttal. The question is asked. The question is based upon the record. There's a curative instruction given. There are repeated comments by the judge prior to the discharge of the jury, and you didn't call. So the question that is puzzling me is, how are we to balance your strategy as a trial lawyer compared to your argument now that that question withdrew the credibility decision by the witness as opposed to the jury? The two are just disparate.
Well, Judge, it's my opinion, it's the opinion of the trial judge who was there, and it's the opinion of the Superior Court. Now, if you want to challenge my trial strategy, I'm happy to describe it to you. It is very clear.
I can easily find a
Judge, it's very, if I may, Your Honor, it's very clear that Dr. Reid was a physician who was rendering an opinion based on his expertise.
Dr. Reid? Sir,
yes.
In your own brief, on page 11, you specifically say Dr. Reid was proffered as a fact witness.
Are we going to have
Counselor.
Yeah, let Justice Doherty ask his question and then you answer it. Sure, you won't prevail here by arguing with him.
I understand that, but I'm getting argued to and told that I'm ridiculous. So I don't know what to do with that, Judge.
I'm suggesting, Counselor, that in your brief to this court on page 11, you quote the reproduced record, and you yourself call your witness a fact witness. Yet you stand here today indicating he's an expert. So I ask you so that you can clarify, is your brief right or are your comments here today correct?
Your Honor, I think if you look at the record.
It's a simple question, sir.
Go ahead and answer, Mr. Haynes.
I think if you look at the record, you will see that I described Dr. Reid as an expert to the jury in my closing.
But you did not have him certified as an expert as well as a fact witness with the trial judge, correct?
Judge, Dr. Reid was a part of the care of Mr. Steltz.
Right.
He's not a hired independent expert.
Right.
I don't, if I don't identify him as an expert, I don't have to submit an expert report to him. He is not presented as someone who I brought to the front. He comes from the medical piece. That's the mechanism by which he was called.
Right, and Mr. Haynes, I'm not challenging your decision to bring him as a fact witness. He clearly was a fact witness.
Right.
But my question is, could he also have been certified by the judge as an expert? Because, you know, you describe him and he is an expert, but he was presented to the jury solely as a fact witness. Couldn't you have done both?
I think the answer to I think the answer to that question is yes. She could have clearly done that, but that raises a whole issue with respect to, is he qualified to be an expert? And I was offering him for the purpose of showing this is Dr. Reid, this is the doctor in this case who interpreted this MRI and rendered an opinion about it. He's clearly an expert without identifying himself as an expert. Now, if I can go back a minute, when Mr. Snyder asked that question, he's got a very able defense lawyer here. Mr. Snyder wasn't reading, now Dr. Zoga, do you agree that do you understand that out of 5,000, the plaintiff couldn't find one? That's not what happened. Mr. Snyder was at the bar of the court.
Please, you're not arguing to a jury. We need you to the microphone. We're all.
Right. He was at the bar of the court in front of Dr. Zoga on his tiptoes with his hand out. And when the objection was made, he kept going. Not one. Now, the first thing I wrote when I started to read my opponent's brief was, what's a little lie among friends? I mean, what Mr. Snyder said was a lie. Plain and simple. There is not a fact in the record that suggests how many or if any of the 5,000 radiologists were talked to. There's nothing that would support that statement. But what he was saying to the jury was, you realize, members of the jury, that what Dr. Zoga has told you about his credentials is so strong and so powerful that the plaintiff can't bring anybody in here. And the distinction that suggests about didn't and couldn't is really a distinction without a difference. To this extent, it's one thing to say the defendant, the plaintiff couldn't. He just couldn't. What does that say? I wasn't able to? Now, you all know what it's like to get an expert, and I don't want to get into all of that, but the implications are enormous. And in this context, the context of this case, what it did was leapfrog Zoga over anybody and everybody. There was no one that could possibly criticize Dr. Zoga, and that was the prejudice.
Although
that was the hurt.
And I understand that, and again, you've managed to come as appellant, which is always a good place to be here. Appellee, I'm sorry, which is a good place to be in our court. But the question is, I agree with you. I said to Mr. Hare, there was no foundation, assume facts not in evidence, attack credibility. It was a completely improper question. And I don't think Mr. Hare actually would seriously fight about that. What he would say is that there was not sufficient prejudice to grant a new trial. And one of the things he said is that you had ample opportunity to, because the trial court did not grant the mistrial on the spot, to rehabilitate. You could have called Dr. Chekhov. The trial court gave you the opportunity to do rebuttal. You could have countered Dr. Zoga in all sorts of ways, and you didn't do it. And therefore, you have an abuse of discretion here. And that's what I think you need to answer.
With all due respect, Judge, Your Honor, Justice, you're assuming facts not in evidence. You don't know why I didn't or couldn't call Dr. Chekhov. and the record doesn't reflect that. So you can't speculate on the reasons. If I tell you that Dr. Chekhov's practice was purchased by Dr. Zoga's practice, and he therefore would that...
Counsel, doesn't that defeat your position? You're sharing, he's assuming facts not in question. The only thing before that jury was your witnesses and Dr. Reid and defense witnesses and the expert. And there was a contest of language between counsel. And the question, as Judge Bowe said, was based specifically upon the evidence. And despite the fact that there is known to be at least 5,000 experts that do this particular thing, none were called.
Right,
and that is as a result of trial strategy. So, and then there's a curative instruction. So I'm still somewhat confused as to, now you're saying to Justice Speier, you don't know what I did because it's a trial strategy. But you're right. So explain that, because your comment to Justice Speier flies in the face of your argument.
I'll be happy to explain that. I thought I just did, Dr.
Well,
Check.
you did not clear enough, sir. Let's be respectful. It's obviously how this was. You're not being very respectful.
We're about done. Answer Justice Doherty's question, and we'll move on to the next case.
Okay, look, I think at the end of the day, Judge Stey is a very deliberate and very cautious and very effective judge. And if you read this transcript, you will see that. And it is clear that this judge, after the fact, went back and reviewed this and said, in my opinion, this was so prejudicial that it warrants a new trial. Now, certainly the lawyers in the courtroom believed that at the time it occurred because of the circumstances under which it occurred. And certainly there was a heated argument among all the lawyers about that at the time, because we saw the impact of what had just been said, that nobody could come in here. You can call anybody you want, they can't compete with Zoga. Now, I heard the argument about rebuttal. How's that proper rebuttal? How would I do that? What would I...
Trial court gave you leave to call Dr. Chekhov. You had a certificate of merit from, a report from, put on the stand.
And then I'd be here on the issue of whether or not that was proper rebuttal, because I don't see how that would be proper rebuttal. Dr. Reid,
make the offer.
I'm not sure, frankly, that an I'm not sure, frankly, that an expert would be appropriate in the first place because it's cumulative. There is evidence of an opinion about what was seen on that X-ray. So to call, as I understand it, it's improper to call a witness to say, the first witness was right and I agree with him, which is what an expert would have added to the mix here. And that in and itself, I don't think it would have been proper for me to do.
All right. Any questions from any of the justices? Thank you very much for your time. We'll call the next case.
argument is the Commonwealth of Pennsylvania versus Brendan Patrick Young and Daniel Casey. Representing the Commonwealth is Mr. Hugh Burns. Representing Mr. Young is Mr. John F. Riley. Representing Mr. Casey is Mr. Stephen Triolis.
These consolidated appeals present the court with another question regarding the applicability of our recent decision in Commonwealth versus Walker. In the cases before us, 2 appellees were charged with multiple crimes. 3 preliminary hearings were held in each case, and at the end of each hearing, some of the charges were held over and assigned a docket number. As a result, the criminal proceedings against each appellee were assigned 3 separate docket numbers. Appellees filed motions to suppress. The trial court granted appellee suppression, and the Commonwealth appealed, filing 2 notices of appeal, 1 for each appellee, with each notice of appeal containing 3 docket numbers specific to each appellee. The Superior Court quashed the appeals, holding the Commonwealth's failure to file separate notices of appeal at each docket number violated our decision in Walker. We granted allowance of appeal to address the propriety of this ruling and to further explore Walker. I understand, Mr. Riley and Mr. Triolis, you're going to argue separately. You're welcome to each argue. Just take caution to not repeat each other. Thank you. Mr. Burns, nice to see you again. Please proceed.
Good to see you, Your Honors.
Mr. Burns, we used to see you all the time when you were with the DA's office. Now we hardly see you.
The pace is less intense, but
well, welcome back.
Good to be here, Your Honor. Thank you. And may it please the Court, Hugh Burns for the Commonwealth. Under Always Busy Consulting, Walker doesn't control when 1 notice of appeal is filed in 1 case, and that is what happened here. Always Busy Consulting and Walker both construe Rule 341, the note to which cites this Court's decision in Malanchuk versus Tamura, a case where this Court held that under Rule 341, consolidated actions become 1 case when there is complete identity of parties and claims. In Always Busy Consulting, there were 2 docket numbers because there were 2 actions filed, but in substance, those actions were 2 sides of 1 coin. The 2 docket numbers didn't turn 1 case into 2. Instead, consistent with Malanchuk and Rule 341, in Always Busy Consulting, this Court held that even with 2 docket numbers, 1 notice of appeal only was required because there was really only 1 case. This case is stronger than that in Always Busy Consulting because there it was at least arguable that there were 2 cases because 2 actions were filed. In this case, there's always been only 1 action. Certainly, there are 3 docket numbers. The case accumulated those because there were 3 preliminary hearings, but that's a process that's analogous to amending a complaint in a civil case. Amending the complaint doesn't create a new case, and amending the complaint more than once doesn't create multiple cases. It remains 1 case, and that is in stark contrast to the Walker case where 1 notice of appeal was filed for 4 defendants. Walker explained that that creates confusion, places an undue burden on the appellate court when 1 notice is filed when there are really 4 cases, but requiring 3 notices when there is only 1 case just creates the same problem in reverse. Now, the defendant has argued that in Always Busy Consulting, the consolidation order was different. There was a lead docket number assigned, and the order was jointly requested. That's really not a distinction. It's really just a difference. In fact, I would go so far as to say that looking at this Court's cases in Malanchuk and Kinsey versus Petro, going even back to the case of Azinger versus Pennsylvania Railroad from 1918, what arises out of these cases shows that the consolidation order really doesn't do very much. The point, the critical factor is identity of parties and claims, and that arises out of the cases. It isn't something that's given to the cases by a consolidation order, and if you do have identity of parties and claims, not having a consolidation order doesn't take that away. So,
Counsel, why is it then that the trial court ordered that the documents be filed at each of the individual docket numbers?
I think that was a matter.
In Busy Beaver, there was a true consolidation. In this case, it appeared to be the trial court's intent that the dockets remain separate. And then let me just follow up with something that seems to indicate that the Commonwealth understood that to be the case also. And maybe you could explain this to me. One notice of appeal was filed, one original notice of appeal was filed, but then photocopies of that notice of appeal were filed at the other two docket numbers with those docket numbers highlighted in yellow. So, obviously there was a recognition here that there were three docket numbers that were being affected. Why file those photocopies of the notice of appeal?
The clerk actually filed the photocopies, but in fact, considering the manner in which the Superior Court has construed Walker since it was decided, if the Commonwealth had filed the three notices, each with three docket numbers, the Superior Court would have held that that satisfied Walker. The reason that there was a consolidation order was, as often occurs in these cases—
Where was there a consolidation order, counsel? Where was there a consolidation order?
In the trial court.
Even though the documents had to be filed separately at each of the docket numbers?
The court ordered that the documents would be filed at each docket number. But I think that that only confirms that there's only one case. In fact, if you look at the docket entries after the preliminary hearings were done and after the consolidation order was entered, as I think a matter of administrative convenience, all of the docket entries were the same. No, I don't think so. As I said, I don't think a consolidation order in a case like this is even necessary. You can argue about what the consolidation order said, but this court's cases make it very clear that when identity of parties and claims is lacking, the consolidation order doesn't give that to the case. And by the same token, if you do have identity of parties and claims, I would argue that even the complete absence of a consolidation order doesn't take that away. The defendant also argues that in Always Busy Consulting there was a breakdown in court operations. Again, I would argue that that's not necessary. This court's decision, when you read this court's opinion in Always Busy Consulting, it's pretty clear that the basis for this court's holding was not the breakdown in court operations, but once again, the identity of parties and claims. And to the extent we need a breakdown in court operations, I would argue we have one here. When we got to the Superior Court level, the Superior Court wouldn't allow us to go ahead and ratify what the clerk had done and file duplicate notices. That's a breakdown too. It occurred at the appellate level, but that's, again, not a distinction, merely a difference.
Mr. Burns, was Walker correctly decided?
Under the facts of that case, I think it was. I might suggest that the court revisit the idea of insisting that the case be dismissed in the event of a mistake in not filing enough copies of notices.
Let me ask as a follow-up. In ABC, and I actually opened up to it because I thought I was correct, but the language is recently in Walker, our Supreme Court construed the above language as constituting a bright line mandatory instruction to practitioners to file separate notices of appeal. That was the Superior Court. Now, is that a correct statement?
Well, Walker did say that it's mandatory to file multiple notices when there are multiple dockets and multiple defendants, and I don't think anybody would argue with that. That's perfectly consistent with everything that this court's decided under this rule up until today. I think the departure is that, at least in the way that the Superior Court read the case, the Superior Court read Walker to mean that there is no discretion at that point once it's been determined that there were multiple cases but only one notice filed, that the appeal had to be dismissed.
I note that Walker, we made prospective. In all ABC, we didn't apply it, and today you're asking us not to apply it. So it's an unusual bright line rule that's never been used by the court in subsequent
Well,
cases.
to follow up on your question, it wasn't applied in Walker either. As you said, it was only applied prospectively. And so in Walker, the appellant in Walker actually violated the rule in Walker, but it was allowed to go ahead and continue with the appeal.
Counsel, may I ask this question? If these three docketed numbers emanate from the same episode, and they are required to have three separate notices of appeal, and let's hypothetically say one is 2 aggravated assaults because there were 2 defendants, and 2 conspiracies, but they were separately docketed because they were dismissed and held for court on a subsequent case. In this particular factual scenario, 3 preliminary hearings. The question or concern that I have is, if they're filed separately, how do you choose as the Commonwealth which takes priority? You cannot, hypothetically, let's say it's a sufficiency weight argument before the court. How will you determine if we follow this rule to its logical extreme? Can you decide and litigate a ag assault case or the conspiracy case against the co-defendant first?
Well, I think that question was actually answered by this court in Collin versus Karetny from the appellate perspective. In that case, only one charge was quashed, but all of the charges came up on appeal because this court held that they had to be considered together. Otherwise, some charges might be tried before the other ones could be reached, and double jeopardy would prevent those charges from being considered. So from the perspective of the appellate court, even if there's an argument to be made that some charges are not equally situated as others, but they're all being brought in one case, they should all be considered together on appeal. And once again, we're not talking about considering whether there's identity of parties and claims in order to merge together different actions. In this case, there was always only one action. So for that reason, we ask this court to remand this case to the Superior Court for consideration of the Commonwealth's appeal and the merits. Thank you, Your Honors.
Good afternoon, Your Honors. May it please the Court. I believe that the Commonwealth's argument is built on the erroneous notion that these 3 criminal cases, these 3 criminal actions, are in fact one case. They're not one case. They're 3 cases, 3 separate cases. Justice Baer, in introducing them, described the procedural history. The Commonwealth filed 200 counts of various crimes against each defendant to start. 3/4 of those were dismissed after the first preliminary hearing. The Commonwealth then filed a second criminal complaint, a second criminal action, second preliminary arraignment, second bail, ultimately a second transcript number in common pleas when the one charge out of those 100 and some charges in the second complaint was held, when that one charge was held. And then again, there was a third criminal complaint which involved 50 or 60 or so charges, from which there were 30-some charges that were held for court. The Commonwealth elides this procedural history because I think it reflects unfavorably on the Commonwealth's position. In fact, there are 3 separate criminal complaints here. As I said, 3 separate complaints, preliminary arraignments, three sets of criminal information.
Do those complaints all refer to the same date, time, and action?
They do not, Your Honor. They do not. Each of the criminal complaints alleges crimes that occurred at different times. One complaint concerns the spring of 2016, events that occurred in the spring of 2016. One concerns events from the fall of 2016, and the third involves events from February of 2017. In each case, although there's some overlap in the crimes that are charged, the allegations are different, the facts are different, the witnesses are different, the participants in the events are different.
Correct.
Yes, Your Honor.
Did the Commonwealth not null pros the 2016 incidents and only look to the tragic loss of Timothy Piazza's life?
No, Your Honor.
Okay.
No. The Commonwealth initially filed charges in the first complaint regarding February of 2017 and then spring and fall of 2016. All of the spring and fall 2016 charges were dismissed after the preliminary hearing and then refiled in the second complaint and again refiled in the third complaint. So to suggest that this is in any way akin to the facts in ABC, or to suggest that it's a stronger case than ABC is, I suggest, dumbfounding. ABC involved one arbitration award, two competing petitions to either to confirm or vacate that arbitration award. I think that the decision in ABC was one that was based not only on a judicial breakdown, but also on common sense. I think that if this court, to go back to a point that Justice Baer made just a few minutes ago, here's this Commonwealth versus Walker, and we as the Supreme Court have never applied it. I think that if this court created an exception to fit the facts here, it would be the exception that swallowed the rule. Because
Counsel, I apologize. I'm trying to get some clarification from your comments from the brief you guys submitted. We're looking at 3 preliminary hearings stemming from the incident in which Timothy Piazza's hazing caused his death.
No, Your Honor.
The motion to suppress, for which is the motion to suppress, which is the basis of the appeal by the Commonwealth, because its prosecution is hindered, is based upon, and they're the 3 notices of appeal, correct, from the motion to suppress.
The motion to suppress concerned all 3 cases.
All right. 3 cases, but, so share with me, what were those 3 cases? Were they not the suppression of the text messages from the 2 individuals, the defendants Casey and Young, as to their hiding alleged evidence about Mr. Piazza's death?
The text message evidence included evidence concerning February of 2017, that is the charges that were held after the first preliminary hearing, but also text messages concerning the spring of 2016 and the fall of 2016. Again, I suggest, Your Honor, demonstrating the fact that there are 3 separate complaints here concerning 3 separate events. In no way can these 3 cases be considered to be a single criminal episode. They're so separated by time, separated by witnesses.
Counsel, may I ask you, in Walker, you had multiple criminal defendants in multiple different scenarios, and therefore the ramification from an appellate court holding in that case would have impacted each defendant differently.
Correct.
And it was on that basis we said you can't argue these all simultaneously because of the different journeys the cases are going to take. Now, is that true here, where you have 2 defendants, you have 1 crime, and I understand that you have multiple, you have 1 criminal incident, notwithstanding that the Commonwealth in its prerogative can charge a lot of different crimes
Our position is that we have 3 separate criminal episodes.
And is it
3 separate complaints, 3 different times over a 12-month period.
So if you do not prevail today, and then the Superior Court hears the motion to suppress filed on behalf of each of these 2 defendants and decides them, will that allow the cases to proceed appropriately, or will that create the hornet's nest because the cases are impacted, the various cases, notwithstanding you have 1 defendant, will be impacted differently by that ruling on the suppression motion?
Your Honor, I don't believe that was the gravamen of Commonwealth versus Walker. Commonwealth versus Walker was intended to lay down a mandatory bright line rule for everyone for everyone to follow. The court in Commonwealth versus Walker said, gave the reasons why such a rule would be a good one. You don't want the appellate court to have to go behind the pleadings and whatnot and try to sort through things to determine whether this should be, whether it's 3 appeals or whether it's 1 appeal. But nevertheless, the holding in Walker is to create a mandatory bright line rule. And
May I
yes, Your Honor.
probe this like the Chief Justice did, but view it slightly differently. Starting with Walker, and we all know what it said. One notice of appeal in relation to 4 separate defendants. Our court was concerned if you didn't do that, as you said, you're going to have to go behind the notice of appeal, even to try to figure out if the same facts and issues apply, right? That's Walker. Now here, there was 1 suppression order, granting suppression of the same evidence in relation to all 3 docket numbers, which all pertain to the same defendant, in the same prosecution, based on the same underlying events.
Which were consolidated at trial.
Is that accurate?
They were. No, sir. Your Honor, in Commonwealth versus Walker, you have. Yeah. Well, in this case, you have a 36 or so page order disposing of multiple pretrial motions filed by both defendant Young and defendant Casey. Some of the it was
1 order.
It was 1 order. That's correct. Right?
So we got 1 order, and it grants suppression of the same evidence or different evidence.
It granted suppression of different evidence. It suppressed the cell phone evidence here, but it also suppressed evidence that Mr. Young, testimony that Mr. Young had given in the grand jury, Your Honor.
Suppressed the same evidence in relation to all 3 docket numbers, which all pertain to the same defendant in the same prosecution, based on the same underlying events.
Based on three different underlying criminal episodes, Your Honor. I'm afraid that what you're suggesting, Justice Saylor, would be that because the
suggesting it might be slightly different to Walker.
Well, it's different in that there's 1 order, 1 defendant. There were 4 defendants in Walker. My concern would be that if the court was to hold that this was consistent with ABC and that it was merely the near unity of the motion of the Commonwealth's motion to suppress, that is the motion regarding the cell phone evidence, that if that was the only rule, then we're back to the General Electric case. The General Electric case said that where the evidence on appeal is substantially similar, then as long as the Aplt doesn't appeal and the time for appeal has expired, then it's okay for the court not to require three notices of appeal. And that is where I say that if that's the case, then we're back at General Electric, and the exception here, where there are 3 cases with 3 different sets of claims, then that exception has swallowed Walker, and Walker essentially ceases to exist. Right. There are no other questions?
Counsel?
Yes, Your Honor.
When the Superior Court, hypothetically, would decide this case, would it be affecting orders at the 3 different docket numbers?
Yes.
Would they be entering 3 different orders? They'd say the order at docket 1 is affirmed, docket 2 is affirmed, docket 3 is affirmed, or could they just enter 1 order?
Well, it's only docketed at the Superior Court under 1 docket number. The evidence, the cell phone evidence concerns all three complaints.
In an appropriate appeal, would it be necessary to enter 3 different orders in order to impact the 3 dockets?
No, not if the Superior Court had consolidated the cases on consent or on its own volition. In the ordinary course of things, if the Commonwealth had followed Walker in this case, then there would have been 3 docket numbers. It would have been necessary for 3 appellate court orders.
Since there were photocopies of the notices of appeal that were filed in this case, they were filed at the 3 different docket numbers. Could those notices of appeal be amended, so to speak, to make them the equivalent of original notices of appeal? I mean, there's no question that there were pieces of paper filed at each docket number indicating that an appeal had been taken, correct?
Yes, Your Honor.
Everyone, knew that from the beginning of this case. Why would it not be appropriate to consider those photocopies as notices of appeal?
Because the note to Rule 341 and this court in Walker said it's necessary to file a separate notice of appeal at each docket.
Well, the only thing that doesn't make these actual notices of appeal is because no filing fee was filed at those 2 other docket numbers.
Well, I would say that it's because the Commonwealth only filed a single notice of appeal in violation of both the Court of Common Pleas order to file each document at every docket.
I understand that.
And Walker.
I'm just talking about the pragmatics of what the record looks like in these cases. There is a photocopy, which we only know is a photocopy because we've been told it's a photocopy as opposed to an original. There are 3 documents that purport to be notices of appeal. Why not treat those other 2 photocopies as notices of appeal in this case? In other words, allow an amendment for that purpose?
Because it's not consistent with the note to Rule 341, and it's not consistent with Commonwealth versus Walker. I mean, the reason that we're here is because Commonwealth versus Walker exists, laying down a bright line mandatory instruction to all parties. I mean, in this case, the defendants both explained in their briefs that the defendants were also burned by Walker in this case. So at the time that the Commonwealth filed its interlocutory appeal, the defendants also filed interlocutory appeals requesting the Superior Court to grant permission to appeal a constitutional claim regarding the hazing statute. The Superior Court dismissed the defendants' petitions under Walker. So I would suggest, furthermore, beyond the arguments that I've already made, that given that Walker, in its full rigor, the strict rule of Walker, has already been applied against the defendants in their own attempt to take an interlocutory appeal, that a different, less strict, a relaxed rule shouldn't be created for the Commonwealth in this case so that they can take theirs. I'd suggest
was that appealed?
It was the defendants to this court. The defendants denied a petition for review of the Superior Court.
Right. Yeah. All right. Thank you very much.
Thank you, Your Honor.
Co-counsel.
Thank you. May it please the court. Attorney Steve Triolanis on behalf of Daniel Casey. Walker was very clear. I mean, it created a bright line rule, and it honestly could not have been more clear to litigants in Pennsylvania what was required. And I think part of the confusion within this case is that the Commonwealth, in reading Rule 341 in its official note, and Walker, where it requires, if there is more than one lower court docket, that separate notices must be filed. And the Commonwealth is taking the position that a lower court docket and a case are different, that you can have one case stemming from 3 lower court dockets. What distinguishes the Commonwealth's position from the litigants in ABC, the litigants could not comport with 341 and Walker. They attempted to file a second notice of appeal, and because the trial court's order in ABC listed a lead docket, the prothonotary in the Court of Common Pleas refused to accept. So that was truly a case where...
That was the breakdown of the court apparatus, but that was in the alternative. There was also an argument that we shouldn't put form over substance, and the substance in ABC. And I thought, before listening to your co-counsel's argument, the substance in this case is you have 2 defendants, you have one specific crime, the death arising from the death of one individual, and that one argument on the motion to suppression and one opinion would decide everything universally, which would be applicable to your client, applicable to your co-defendant. And we wouldn't have to look, as Justice Saylor said, behind the shores to see how it impacts. And evidently that's wrong. Is that correct?
Well,
you agree that's
potentially,
wrong?
Depending on what the trial court would do. In this case, the consolidation order, in addition to the requirement that all pleadings be lodged at each and every docket, it was also not final. If you read the consolidation order, there are 3 instances where the trial judge said, with the facts currently before the court, as it presently stands, and the court specifically indicated in the consolidation order that it would revisit the issue of consolidation after the omnibus pretrial motions were resolved. So depending on what the Superior Court would have done with the suppression issue, for instance, if they had overturned it, that evidence might not be admissible at one of the lower court dockets, in which case it could present...
It might be admissible on another.
Exactly right, exactly right.
And the most worthwhile thing I've heard today. Thank you on this case.
And again, the Commonwealth certainly could have filed all 3. And is it form over substance? It's exactly what this court required under Walker. You know, they could have lodged the 3 appeals. Walker was a form over substance case. I mean, I think one of the issues in the old doctrine was where does the burden rest? Does it rest with litigants to be familiar with and understand and comply with the rules of appellate procedure? Or does it rest with the intermediate appellate courts to go behind the notice of appeal and determine, is this one case, one issue, one claim, one party, or are there multiple? And this court in Walker said, we're putting the burden on the litigants. It's up to you. We've created a bright line rule. You have to comply with it. When you don't, the results are harsh, as we've experienced, because we lost our right to that appeal. With respect to the Commonwealth's position that this is really one case, I mean, bail was assigned in each case. Clients had to be fingerprinted in each case.
Would one suppression opinion deal with each, for your client? Who do you represent?
Daniel Casey.
Okay. As to Mr. Casey, if the trial court wrote an opinion in support of suppression, if the Superior Court wrote an opinion in support or against the suppression, would that deal with universally everything involving your client, regardless of what docket number?
Yes, it would. Yes, it would.
So then why isn't this whole thing form over substance? Because substantively, one opinion deals with everything, which is what Justice Saylor was asking.
It certainly is form over substance. I believe it was Representative Dingell who said, if I let you write the substance and you let me write the procedure, I'll beat you every time. That's how important procedural rules are. And when they're clear and they're applied to all parties just the same, then you can have a just outcome. When they're amorphous or not defined, you get an instance where they're applied to some parties but not others.
I agree that's a problem, but in terms of the underlying rationale for Walker, you're saying it's not applicable here because one opinion involving Mr. Casey will take care of all of the various crimes charged at the various docket sheets.
Reviewing the trial court's decision with respect to suppression, yes, the outcome that appellate review has on each of the dockets could be disparate. It could affect each
I thought you said the opposite before, and maybe...
No, it could be, if the evidence is, if the opinion is overturned and the evidence comes in, it will not necessarily come in at all three dockets.
All right. Anything? Anything? Anything you'd like to say in conclusion? You don't have to.
No, I'm just...
All right, thank you. Appreciate the argument. The court will stand in recess until tomorrow morning.